Welcome back, and good afternoon, Mr. Sarmiento. You have been named as a witness in this arbitration. To introduce the panel briefly, on my left is Professor Tawil, on my right, Dr. Cremades. My name is Inke Hanefeld. I'm the presiding arbitrator. As a witness in these proceedings, you have to read out a declaration under Article 35.2 of the ICSID arbitration rules. Can you please be so kind to read the declaration out to us?
Gracias.
Thank you. Witness statement. I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Turn to your witness statement. Do you have your witness statement RWS 15 in front of you? Yes?
No.
Do you have it, or do you need it? Maybe it would be helpful. It will be handed over by the Respondents' Council.
Yo tengo un
here.
ejemplar. Sí.
He has a copy.
Your witness statement, can you confirm that this is your witness statement and that it corresponds to your recollection? Or let us kindly know if there is anything to amend or to correct?
Yes, it is my statement.
Anything to add or to correct, or?
No.
Okay.
No.
Then we will turn now to the Respondents' Council for a brief direct examination.
Thank you. Good afternoon, Mr. Sarmiento.
Buenas tardes.
Your witness statement, is it
Good afternoon.
your personal knowledge and experience?
Yes.
Please describe your educational background.
Soy
I am an attorney, graduated from Lima, Peru University, with a master's degree from the University of Barcelona, and I became a vocal in 2010 at the tax tribunal. I've been there for 13 years.
Please describe the process of deliberation by which a chamber resolves a case that is before the tax tribunal.
As you just mentioned, it is a deliberation process since it initiates with knowledge about the case filed by the vocal ponente, that is the one that reviews the case file and points out the arguments and the controversial issues, as well as the arguments by the parties, and then a draft is prepared that can be done just by the vocal or with the help of a law clerk that will, and this report will later be communicated to the other two vocales. There is a maximum of 3 in each chamber for full knowledge and also to see whether on the day of the hearing we fully agree on the project or on the draft. And at some times, as we saw it in this particular case at chamber number 10, the deliberation process starts much earlier. For example, in our case, with the oral report. The oral report was developed 2 months before the date of the hearing, and as part of this report we had the administration and the taxpayer, and they presented their arguments and also the rules and regulations that they deemed applicable, and we could see what the controversial issues were, and from that moment onwards we could have a clear idea as to what would be the sense, the meaning behind the resolution that we would issue. Finally, after the whole process, we reach the hearing day, the session day, and in the case of Chamber 10 and the other chambers, we all agree that that is how we were going to issue our resolution. So after a brief conversation, we would reach an agreement.
According to claimant in this case, Chamber 10's resolution in Cerro Verde's appeal of Sunat's resolution on the 2006 to 2007 royalty assessments is almost identical to Chamber 1's resolution in Cerro Verde's appeal of the 2008 royalty assessments, and that suggests that there was no deliberation on the part of Chamber 10. What is your opinion?
It should be stated that there is a universal legal principle that we clearly apply at the tax court, that is the previsibility principle. If there is a resolution that resolves a case on a taxpayer and on a controversial issue, and it turns out that there is the same controversial issue and the same taxpayer in another case, by application of the principle, the first resolution should be the same as the other one. Is the principle of the case law and the previsibility, and it wouldn't be predictability, and it wouldn't be strange to have two resolutions that are similar. But I should also mention that at the level of the tax court or the tax tribunal, in spite of this previous case, we could decide differently, because if the vocales thought that the case law was not the actual interpretation or solution to the problem, we could present this for the consideration of all of the vocales as part of a chamber plenary chamber. But this was not the case. We all agreed with the previous case law, but even though this could have been a copy and paste, which was not, at chamber number 10, we had some reasoning that we thought was typical to this case in particular, and that were not applied to the resolution of Chamber 1. Some ideas that were only applied to the resolution of Chamber 10, just to mention one among many that we consider in the room. For example, we have the topic of the final product. The final product in the investment project that was stabilized by Cerro Verde was something that is known as copper cathodes. Copper cathodes, once again, is the production after a chemical procedure or process that is known as leaching, and this is what was provided for under the stabilization contract. Production and leaching of copper cathodes. But later on there was a new project, and this new project had a different product that was copper concentrates with a different product, and this was not going to use leaching, but it was going to use concentration through crushing and also floating of the minerals. So for us, it is one among many elements that are important to be taken into account, and also that led us to this decision.
Por supuesto.
In your witness statement, you explain that Chamber 10 independently deliberated in the 2006-2007 case, and its resolution is not a copy of Chamber 1's resolution. Claimant has put on the record a comparison of the two resolutions, and if you could please, with reference to that comparison, explain some examples that show your independent deliberation. And we'll put it on the screen for you.
Ok.
Thank you.
Muy bien. Solamente para...
Very well, and just to recall, and I will try to speak slower. Our resolution is not the same because we have seen several elements that are different and that were logical to reach that solution and that resolution, and this is what we see here. This is the comparison between the comparison of the resolutions in Chamber 1 and Chamber 10, our chamber. For example, at page 1, I see in blue what would be the new text in Chamber 10 instead of Chamber 1. So I see 3 lines in the first paragraph to 3 issues that were not addressed at all in the resolution by Chamber 1. These are violations by the taxpayer that are thereby mentioned in connection with 177.1, 176.1, and 10.2 of the special law, the other 2 from the tax code. This was not addressed in the resolution of Chamber 1, only in Chamber 10 resolution. Clearly, there is not a copy and paste action, otherwise we wouldn't have looked at these aspects. If we could look at page 15. If we look at page 15, we could see that some paragraphs are identical, and the identical paragraphs have to do with the arguments presented by the taxpayer, which are the same in the draft resolution by Chambers 1 and 10. So the arguments by the parties are exactly the same. So the ones that do not have changes are copy and paste, correct? Yes, clearly, because the arguments are the same, but the drafting of the tribunal is the same. Is that copy and paste because the arguments are identical? No. The copy and pasting is only if all of the resolution was copied and pasted. But if the draft is the same, there are not 2 persons write the same way. So I'm asking you that in those cases you copied and pasted and you only introduced changes whenever things were different, correct? Yes. Those paragraphs where you see no modification are identical to the ones of Chamber 1, and that is copy and paste. Yes, that is copy and paste. I was telling you that the logic we worked with in Chamber 10 was different, starting with the first paragraph that I showed you on the first page, and it was identical in those paragraphs that you just mentioned, and also it is the same regarding the legal rules and regulations and the drafting of the stability contract. There couldn't be any difference. It is the same stability contract from the very first to the last word of the paragraph. It should be the same. There can be a change. So changes, for example, page 15. At page 15, we can see, this is page 15, if we can look at page 15. Here we see an argument that was completely new for Chamber 10, and that is the restrictive interpretation. Restrictive interpretation is applied to special rules and regulations, exceptional rules and regulations, such as the one conferring benefits, such as in the case instant. According to the national laws, here you see one of the authors out of the 3 that we mentioned here. That author indicates that in these cases you should adopt a restrictive interpretation that is to be applied only to cases there is no doubt. Whenever there is doubt, the benefit rule should not be applied. This is a new topic that was not in Chamber 1, in the resolution of Chamber 1, rather in the resolution of Chamber 10. And if we move on to page 32, at page 32, we have a whole paragraph that is completely new. And this completely new paragraph that is our own reasoning, the reasoning of Chamber 10 is trying to explain that there was then another mining company that also had stabilized mining projects. This different mining company, Yanacocha, had an economic administrative unit, and within that unit there were 2 or more concessions. And this Yanacocha mining company had 2 concessions within this unit, and each of these concessions had 2 stability regimes that were different. Then, as part of that administrative economic unit or economic administrative unit, there were 3 different stability regimes, and in our opinion there was a logic that was attempting to show that the argument by the taxpayer was not the same, because in this type of economic administrative unit, if one unit was approved, it applied to all of it. It is not consistent with what we are saying here, which was a confirmation of what had already been decided by the administrative authorities and also by the tax administration, and also the way it was done with other mines. I think that this is enough to explain that.
Confirmation process. Sure. As a vocal, you are subject to a confirmation process, in Spanish, the ratificación, which we understand is led by a commission of which President Olano is a member. Does that affect your independence when resolving a case at the tax tribunal or your testimony in this case?
No, it doesn't. At that time, 2013, there was no confirmation process pending. Ultimately, it happened in 2018. And at this time, as far as I know, there is no ratification process. And I would also say that Ms. Olano is one of 4 members of, as I understand it, who make up that commission. She doesn't chair it either. And these members act, as established by the law, through objective indicators regarding the efficiency of the tribunals during the years we've been working. So there is no sort of influence at all.
After you submitted your witness statement, claimant introduced to the record a resolution of the tax tribunal from 2018 in the case of the mining company Tintaya. You were vocal ponente in that case. Could you please briefly explain that resolution, which we'll put on the screen for you? It is CA 446.
Go.
Of course. If you would be so kind as to turn to page 5. At page 5, one finds the discussion that is relevant for our case, which is the issue of the economic administrative units, as one can see. Now, this is just 4 paragraphs. There's no analysis set forth there about the economic administrative units. The analysis there is for a case in which there being 2 stabilized investment projects, and one has profit and the other has losses. The issue is whether one can offset the profit on one side with the loss on the other, the idea being that each investment project has to calculate their income tax separately. That is what is at issue. Nonetheless, there being economic administrative units, the relevant thing is in the antecedent, which is indicated practically in the last paragraph. And this is the background of a resolution of 2013 where, by chance, I also participated, and where there's analysis of the economic administrative units and the role of a stability agreement in these. And we could turn to this and also the antecedent that is mentioned in paragraph, or rather at page 8. If we go to page 8, that's it, page 8. Now, in the last paragraph, a legal provision that we think is important is indicated. I should note that it is one of those provisions that grants investors tax stability. That's Article 7080 of the General Law on Mining. And in Article 82, it says specifically contractual guarantees, tax stability will benefit the title holder of the mining activity. And now I note exclusively for the investments. That is to say, tax stability is granted exclusively to this concept called investments. And of course, if I continue reading, these investments may be made in concessions or economic administrative units in the one or the other.
Time is up. I mean, even like a few minutes ago. So I'm sorry, Madam President.
I just
Yes,
did
I'm
not
sorry.
want to interrupt the witness.
I was saying that I don't want to interrupt, but it's already been a couple of minutes over his time. So I think it's due.
There was the question from the tribunal.
But even considering that, I think it's time.
Yes, you'll finish up.
Then we hand over to the claimant's counsel to continue with the
Perfecto, sí,
examination.
sí.
Thank you, Madam President. With your permission, I'm going to switch to I think they already have it. With your permission, I'm going to switch to Spanish. Señor Sarmiento, mucho gusto.
Mr. Sarmiento, it's a pleasure to meet you. Good afternoon. How are you? Delighted to see you once again. Likewise. Mr. Sarmiento, first a clarification. The entire resolution that you referred to, for the record, is CA 446, is of 2018, correct? Yes. Fine. Then, in your direct, you spoke of a principle of predictability. Do you recall that at the last hearing we had an exchange on this topic? At the last hearing, I asked you whether to carry out the principle of predictability, it's necessary to cut and paste, right? And you said it is true that obviously one need not copy and paste to carry out this principle. Do you recall the exchange? Yes, I do. And I said that there could be a copy and paste, but that in our case there was no such thing. So your position is that you've never copy and pasted in resolutions? Of course not. I also recall that at the last hearing I asked you whether Chamber 10 had a draft of the 2006-2007 royalties case before receiving the resolution from Chamber 1. And you answered there must be a draft. But it's too many years that have gone by and I can't remember that. But you said there must have been a draft that we saw prior to the session to be able to adopt our decision. Do you remember your testimony in that regard? And I'm sorry for interrupting you, but it's just a yes or no answer. No. You don't recall having said that? It's up on the screen. Yes, I do remember, but not expressly what you say. So your testimony is that the transcript is incorrect? If I read the transcript, I could tell you the transcript is in yellow, correct? Yes. There must have been a draft, but it's too many years and I can't remember it. But there must have been a draft that we saw prior to the session. Yes, exactly. Prior to the session. Yes, I remember that because it's likely that I received a draft one day before the session. Fine. But as I say, it's so many years that have gone by, I can't say for sure. And that draft, which you mentioned that you must have seen before the session, could not be the decision that was ultimately adopted, for as we saw, it was 85% similar to what Chamber 1 decided. Is that right? I don't understand your question. The question is, if there was a draft that had been prepared by Chamber 10 independently, that draft could not have been the draft or the same resolution as Chamber 10 adopted, because that one has a high level of similarity to the decision issued by Chamber 1. Yes, the problem is that your concept of, it has to do with your concept of draft. This draft that we received prior to the session was a draft that it is provided 1 or 2 days before the session based on how we normally work. And this draft that we received includes the draft as the vocal ponente would like it to turn out in the final decision. And we must have had that draft 1 or 2 days earlier. I repeat, I don't remember if it was 1 or 2 days, but clearly that draft had to include everything that had been taken as a precedent from Chamber 1, because that had happened a few days earlier. You didn't answer my question, Mr. Sarmiento, because my question, and it's up on the screen, is you received a draft, and that's what you testified to, that you had a draft before you received the resolution from Chamber 1. And you said, yes, there must have been one. That's what you said on that occasion. What I'm saying is that we saw a draft before the session, but not that it was a draft that existed prior to the session. What I said with regard to the existence of a draft before the session of Chamber 1 is that in reality, I don't know if there was or was not a draft, because I was not the vocal ponente. It was not my mission to prepare that draft. And if there was a draft prepared by the vocal ponente, it was probably some notes and their logic. That I never saw. But a moment ago, you said that it's likely that in Chamber 1, you already had a draft before having received the resolution from Chamber 1. We agree on that, right? It's likely that the member, the vocal, who much before would have had a draft. Nonetheless, I would have had to have received a draft before the session, which is the draft that is eventually adopted as the resolution of Chamber 10, which you're all familiar with. And do you remember having testified at paragraph 15 of your witness statement, which you have in front of you as well? You have it right there. You said that vocal Moriano was upset because Chamber 1 had not shared its preliminary conclusions with you in Chamber 10, who were already familiar with the same analysis on the merits of the case. In other words, Chamber 1 did not share the draft or the resolution with you until after it was issued. Do you remember that, yes or no? Do you remember having to testify to that, yes or no? If you allow me to read what it says we're simply upset. Of course he was upset, and that's why he sent an email for not having received the resolution from beforehand. You're both speaking very quickly, and you're overlapping when you speak, and so I'm not able to take it down. Apologies. My question was whether you recalled having testified that vocal Moriano was upset because he did not receive in timely fashion or before the draft or the resolution from Chamber 1. Well, certainly I must have told you, and I'm not in the shoes of vocal Moriano, so I don't know exactly. I suppose, based on what I read in the email, that he was upset. That's what I could assume. And he was upset, surely, because of what the email says, because he wanted to take stock of the scope of the resolution of Chamber 1 with some lead time. I must have said something along those lines ahead of time.
Any questions?
If I could just have 1 minute to check with my colleagues. No questions. Thank you.
Then just a few questions from the side of the tribunal. I heard earlier today Ms. Olano testifying, of course I cannot interfere in the resolution of cases. Did you experience interference by her in the decision of the royalty case 2006-2007?
No.
No.
Did you, by other means, sensed that there was some sort of a political pressure on the decision of the Cerro Verde cases?
No, not at all.
Do you remember in your time of being in office at the tax tribunal occasions where people attempted to exercise political influence, or did it never happen in your career?
Fortunately, it has never happened.
And are you aware that Mrs. Olano was ever charged of unduly performing her functions?
No, I'm not familiar with anything along those lines, really.
And in the context of the Cerro Verde resolutions, are you aware that any requests under the transparency law were made, where further information on these cases was requested?
No, the truth is I'm not familiar with those details.
Thank you. That concludes my questions. Have the parties additional questions as follow-up questions?
Not from us. Thank you, Madam President.
Not from us. Thank you.
Thank you very much, Mr. Sarmiento. Then you are released as a witness with thanks. Thank you.
Gracias a ustedes.
Thank you.
Can we then continue with the next expert right away?
Are you going to pass out also paper copies of the same?
Yeah, Madam President, before we proceed, claimant, yeah, we're on the record now. Thank you. Claimant would just like to move to introduce as a hearing exhibit the privilege protocol concerning expert and witness communications agreed between the parties in this proceeding. We believe that it will help reduce the incidence of procedural discussions about this proper scope of cross-examination.
Any objections to this introduction?
Well, I assume this is something that is already part of the hearing proceeding, so no objections, but that doesn't necessarily have, yes, no objections. I guess I have to see it, but I think that's something that's already on part of the record, but I don't know if it's handy. Is it handy? Do you have a copy handy? Ah, I have a copy handy. Yeah, of course.
Perfect. The other housekeeping matter is Mr. Sampliner's hearing aid has picked a very inopportune moment to stop working. We think it'll be fine, but he'll use the headphones. even though he'll be testifying in English, and he'll let us know if he has any AV difficulties.
Yes, please let us know if you experience any difficulties. Can you hear me well?
Be able to function without the headphones, but if they're here, I know the headphones will work if I need them.
Then I take this opportunity to welcome you as an expert and are presented by the claimant in this proceedings. Here on the side of the tribunal is Professor Tawil and Dr. Cremades, and my name is Inka Hanefeld. We are the arbitral tribunal in this case. And under Rule 35.3 of the ICSID arbitration rules, as you may know, you are requested to make a declaration. Can you read it out, what you have on your desk?
Okay. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. And do you have your expert reports, CER 11 and 14, in front of you?
I do.
Can you confirm that these are your expert reports?
I can.
Do you have anything to amend or correct?
No.
Then I understand that you will make a presentation, and we will be glad to listen to your presentation.
Sorry, I need the presentation. It's not have been. It has not been uploaded. I don't have it by mail. I need the presentation. I take notes on the presentation.
Circulated apologies to.
Yeah, I would appreciate both parties upload it in advance, because we need to work on them.
Yeah, we're currently having it circulated to everybody, including the members of the tribunal. Apologies.
Then we wait until Professor Tawil confirms receipt.
Sorry, you have sent it or you have uploaded it?
We have emailed it to the tribunal secretary, and
Mr. Dawood, yeah, so I just received it, so
Yeah.
I'm gonna send it to you in a second. Thank you.
Perfect. Then we can proceed.
Okay. Madam President and members of the tribunal, good afternoon. I am here to testify about my conclusions regarding the certain provisions of the United States-Peru Trade Promotion Agreement based on my experience in negotiating this agreement, as well as more than 20 others during my 20 years of experience in the U.S. government. I'll start with a word about my qualifications and experience. I started at Treasury in late 1998, and from then until 2014, I was the only attorney at Treasury responsible for investment treaty negotiations, including this TPA. For all of my close to 21 years there, I was the principal Treasury staff member on investor state dispute settlement submissions from the very beginning. And they started coming very shortly after I arrived. The first case ever against the United States, Lowen, arrived a little over 2 weeks after I got to Treasury. So I worked on that and every other one for the succeeding 21 years. My time at Treasury turned out to be a key formative period for our U.S. investment treaties, and where I was able to help develop our 2004 and 2012 U.S. model BITs, as well as the FTA investment chapter standard template. I also assisted in resolving investment disputes between U.S. investors and foreign governments. And over time, as I accumulated more experience and a number of my colleagues in state and USTR and elsewhere rotated out, I became more of a repository of information for my U.S. government colleagues. And for example, even after I retired, I was asked to conduct a seminar by my ex-colleagues at USTR called Ask Professor Sampliner about the evolution and origin of our investment treaty and many of their provisions. Let me go now to a summary of my conclusions. First, on Article 10.18.1 on the limitation period. The limitations period cannot begin to run until a breach has occurred and loss has been incurred. Secondly, a claimant cannot acquire knowledge of a breach resulting from a government measure and that it has incurred loss or damage until the government measure is binding and enforceable in the host country. Third, that legally distinct injuries have separate limitation periods, even if they are related. Regarding the fork in the road in Article 10.18.4, this article of the TPA and similar provisions in U.S. treaties only apply when the same alleged breach has been previously submitted for adjudication to a competent forum. Regarding non-retroactivity in Article 10.1.3, the rule does not bar claims challenging post-entry into force measures that are actionable in their own right. And finally, regarding investment agreement claims, under Article 10.28, the definitions, and Article 10.16.1, the gateway to arbitration, investment agreement claims are permitted if either the claimant or the enterprise relied on the agreement. Now I'll discuss a little bit about the negotiation process and about Treasury's role in it. The U.S. negotiates investment treaties through an interagency process where we apply Congress's negotiating objectives through model treaty provisions. If there are departures from these model treaty provisions, they've got to be cleared through an interagency process. The greater the departure, of course, the more debate and higher level clearance may be necessary. And importantly, if there is a deviation, once we deviate, our practice was not to deviate further unless there were very compelling reasons to do so. And further clearance often would have to be required. This picture on the right hand of the screen just depicts my observations of Treasury's role in the process. And often, as in the U.S.-Peru TPA, I found that Treasury took overall the second leading role in our investment chapter negotiations, second to USTR. Here is an overview of our TPA negotiations. They started as the Andean FTA negotiations with Colombia, Peru, and Ecuador. It wasn't until the very end that we realized there would be just a Peru and a Colombia TPA. The U.S. entered these negotiations with a template, and we developed it from first the U.S. model BIT from 1994 and NAFTA, which in many parts were quite different. So we engaged in what we called a BIT Plus exercise from 2000 to 2001, later on in 2003 also, to try to come up with a U.S. best practice that would be applicable for our agreements across the board. In August of 2002, Congress passed the U.S. Trade Promotion Authority statute with negotiating objectives that we had to comply with. And finally, before we started the TPA negotiations, we had just finished our first post-Trade Promotion Authority negotiations with Singapore and Chile. And so the provisions we had there were essentially used as our template, with a few tweaks that came from a little bit of experience in negotiating that, and the next one, which was DR-CAFTA. So that's the template we started with. Personally, I was involved throughout the TPA negotiations. I attended 3 rounds myself, 3 of the important rounds, but in addition, I was always present, as far as I know, at all of our interagency meetings that we had and intra-agency meetings in between rounds to keep up with what was going on and our strategy on what we would do in succeeding rounds. Now let me go to Article 10.18.1 on the limitations period. The article here is in front of you, and it says that no claim can be submitted under this section
I'm
if
not
more
getting
than,
the
yes.
translation. I'm not hearing the interpreters. Yeah, now it's fine. Thank you.
So here is Article 10.18.1, and it says no claim can be submitted to arbitration if more than 3 years have elapsed from when the claimant had actual or constructive knowledge of the breach alleged, as well as that it has incurred loss or damage. A little background to Article 10.18.1 is in this slide. We have had limitation periods standard in our U.S. FTAs since NAFTA. We did not have them in our BITs, so that was one of the subjects we discussed in our BIT Plus exercise. We concluded, after not that much debate, that it would be very helpful to have them, and that the NAFTA formulation should be adopted, and in substance that's what we did. The intent of these provisions were to prevent stale claims and promote certainty for possible exposure in litigation or arbitration. The provisions at the same time were also not intended to encourage unripe claims, and that concept was an important one to us that we emphasized in our negotiations, in many of our ISDS submissions, and in our intra-U.S. government discussions of what positions we could take. The U.S. proposed the Article 10.18.1 in this TPA negotiations early on. It was not much of an issue of contention, and ultimately the Andean parties agreed to it pretty early also without any substantive change. Now, this slide talks about our U.S. practice on these limitations provisions. My personal experience came from negotiating the limitation provisions and many of the agreements where I was involved in negotiating them, as well as working on U.S. ISDS submissions, of which there were quite a few on the limitations provisions while I was there. One of the most common statements that we made in our USDS submissions was just on the definition of incurred, and as the screen notes, it means liable or subject to loss or damage. And the U.S. was consistent in describing that term that way. In addition, we often stated that loss can be incurred even if the financial impact of a measure is not immediate. But, and this is in the MESA submission on the right, another important thing we've always said was that claims can only be submitted for a breach that already has occurred and for which damage or loss has already been incurred, and therefore that claims can not be submitted for future breaches or future losses. Now here is the logic behind my conclusion that government measures must be binding and enforceable to result in breach and loss. First, the limitation period only begins to run when a claimant knows or should know of a breach and that loss or damage has been incurred. Second, as in the last slide, incurred means that the claimant is liable or subject to loss or damage. And third, a claimant can only be liable or subject to loss or damage from a measure that is capable of being enforced. Now, here are some considerations underlying My other conclusion, that legally distinct injuries have separate limitations periods. There have been a number of U.S. submissions concerning a series of similar and related acts. They emerged in response to concern about continuing breach claims, and in particular, after the holding in UPS versus Canada, that continuing breaches may renew claims period under international law, which both the United States and most commentators felt was erroneous. So in these cases, what we've stated, and this is an excerpt from one of the U.S. submissions in Spence, there were several others, so we stated that a claimant cannot evade a limitations period by basing its claim on the most recent act in a series of acts. But what is important to emphasize about these cases, and in this regard they were all the same, is that they related to a single cause of action that could together constitute a continuing breach. What we also said consistently in our U.S. submissions on this point were, and this was said in Spence and all the other cases that are relevant, is that when there is a legally distinct injury, i.e. a distinct cause of action, there is a new limitations period. Okay, let me go to Article 10.18.4 on the fork in the road. Here is the article, and it says that no claim may be submitted to arbitration for breach of an investment agreement if the claimant or the enterprise, as the case may be, has previously submitted the same alleged breach to an administrative tribunal or court of the respondent or to any other binding dispute settlement procedure. Now, there are two key points I want to emphasize about Article 10.18.4. One of them is that it was not intended to apply to anything other than the same alleged breach. This is obvious from the language as well as from its history that I'll get into next. In addition, just in order for this provision to make sense, that courts, administrative tribunals, and other binding dispute settlement procedures must be competent to adjudicate claims for breach of an investment agreement. Now, here is a brief history of our fork in the road in U.S. investment treaties. Our pre-2004 U.S. BITs used a fork in the road for any dispute that the claimant had to make a choice about whether to go to a domestic court, domestic administrative tribunal, or other dispute settlement procedures on one hand, or arbitration under the BIT on the other. And that choice would be definitive. NAFTA was different because it introduced what we call the no U-turn approach, under which claimants can go to arbitration even after they go to any of these other procedures, but they must file a waiver that would prevent them from going back to any of the other procedures for measures alleged to be a breach. In our BIT Plus exercise, we have this difference between the BITs and the NAFTA, and this was one of the most hotly debated subjects internally. And ultimately, our U.S. interagency group decided to use the no U-turn approach rather than the fork in the road, starting with our first FTAs for Chile and Singapore. Same was later done for the 2004 model BIT. The intent of this was to promote broad access to ISDS and to encourage resolving disputes in the local courts. During our negotiations of our initial FTAs, Chile argued that since their courts hear treaty claims, claimants should be precluded from submitting the same treaty claims in local courts and ISDS. There was a provision we had in NAFTA for this that applied to Mexico, whose courts also had similar powers. The U.S. team sympathized with this argument, but provided that the preclusion that might be contemplated only would apply to treaty claims that were raised in the local fora. So that was with respect to treaty claims. We are also starting to negotiate investment agreement claims with Chile, and they made the same argument, saying there could be the same breaches alleged of an investment agreement in the arbitration as was alleged in the local courts or other fora, and therefore that the same argument for a fork in the road should apply to investment agreement claims in that circumstance as for treaty claims. The U.S. agreed, but again, we only agreed provided that the fork applied to the exact same investment agreement claims that were raised in the initial fora first. During our DR-CAFTA negotiations, the same thing, essentially the same progression happened, and we ended up with provisions that had a fork in the road for both treaty breaches that are alleged as well as alleged investment agreement breaches. In our negotiation of Article 10.18.4, the U.S. adopted an initial position, was in our template, for no fork in the road provisions and only a no U-turn waiver provision. The Andean states didn't want to have any investment agreement claims, so we didn't discuss initially a fork in the road for investment agreements, but we did discuss a fork in the road for treaty claims. And the language you see was the Andean proposal regarding a fork in the road for treaty claims, applying to a breach of the disciplines contained under Section A. The U.S. considered that much too broad, and we rejected that proposal. But as negotiation went on, the U.S. indicated that we would have flexibility on exclusive forum selection, and we proposed forks in the road that follow the Chile and CAFTA language. Peru agreed to that language, at the time, the fork in the road was very helpful in getting them to agree to coverage of investment agreement claims in the first place. So they agreed to that, as well as the same fork in the road for treaty claims. And the other Andean parties followed shortly thereafter. But during these negotiations, we did make clear to all of the Andean parties that this article only applies to claims for the same alleged breach. And again, the language, we think, made that quite clear. Now moving on to Article 10.1.3 on non-retroactivity. The article here is in front of you, and as you'll see, it is identical in substance to the Article 28 of the Vienna Convention of the Law of Treaties. And they both say, or I'll read from 10.1.3, that this chapter does not bind any party in relation to any act or fact that took place or any situation that ceased to exist before the date of entry into force of this agreement. For greater certainty, I'll explain in a minute. Now, the key question in trying to apply this provision, or the Vienna Convention provision, to any treaty is which acts or facts don't bind a party with respect to, or can bind a party with respect to retroactivity. And the answer to that question with respect to the TPA is found in Article 10.1.1, because that shows that for the investment chapter at least, that this chapter applies to measures adopted or maintained by a party. That's what it regulates, so that it is the measures that are the relevant facts, or acts or facts, that can bind a party for the purposes of Article 10.1.3. Now, here are the key points that I think have been raised in U.S. submissions regarding the interpretation of this article. First is that pre-entry into force acts or facts can be relevant as background in assessing whether or not a state has subsequently breached an obligation. At the same time, a claim that challenges a post-entry into force measure that is itself a breach does not violate the non-retroactivity rule. And this is what we've said in the Spence submission and in several other submissions. Now, as background to what we did in the TPA negotiations, most of our prior bits, as well as the FTAs you see noted here, had no retroactivity provision. And in fact, our template had no retroactivity provision, because our initial position was that no provision was necessary, because the non-retroactivity rule under the Vienna Convention applied, and under customary international law. But in prior FTAs we had, where the U.S. did include this provision, we used a for greater certainty formulation just to assure that any reader would know that in a treaty that didn't have this provision, it was no less, the principle under the Vienna Convention was no less applicable than it was, well, when we laid it out here as in this case, in CAFTA, in writing. Now, in our negotiation of this article, the Andean states began by, they proposed a broader non-retroactivity provision that you see on the top of your screen here, and it applied to disputes over facts and acts, and it was something that the U.S. Explained we could not accept, that it's too broad, and that we would only accept if we did reiterate the Vienna Convention formulation. And that is what we ultimately did. We used the exact same language as was in the DR CAFTA, and that you'll see and it was accepted pretty early, February 2005, was at the bottom of the screen. Finally, regarding investment agreement claims and the reliance issue under it, the analysis of this starts with Article 10.28, because that is the definition of investment agreements for the TPA. And it is the only provision we have in there that establishes a reliance requirement. And what it says clearly is that the investment agreement is this written agreement between the national authority and a covered investment or investor, but it is on which the covered investment or the investor relies in establishing or acquiring a covered investment. So this is a disjunctive requirement. Either the investor or the enterprise can satisfy it. Now, under Article 10.16.1, and this is the gateway to arbitration, so this talks about the conditions under which any claim can be submitted. The only condition that Article 10.16.1 adds is this direct nexus condition, which you see on the bottom of the screen. The subject matter of the claim and damages must directly relate to the investment that the investor or enterprise established or acquired in reliance on the relevant investment agreement. But again, the nexus is simply between the claim on one hand and the covered investment that happened to be established in reliance on the investment agreement on the other hand. This shows what was in the 1994 model bit, and it shows that this same reliance requirement in substance applied. We used the term investment, national, or company in those days, but it had the same meaning as a covered investment or investor. But either one could rely upon the investment agreement, and that was always part of the definition. So there really was no change, and that's what is illustrated in this slide. Personally, I was involved quite a bit when we updated this in 2004, and we had a very extensive interagency debate about this, and the debate concerned what you see in blue on the screen, and that is what was the scope of this clause? What rights did it grant? And back in the 94 model, it talked about grants rights with respect to natural resources or other assets. Many of our U.S. agencies felt that that was too broad of what other assets, so we ultimately defined it in the subparts ABC in the 2004 model bit that you see in blue there. However, the reliance requirement in yellow was exactly the same in substance. It did not change at all into the 2004 model. Now, this is what we did in the 2004 model regarding the direct nexus requirement. And again, all we did was add this nexus between the claim and that the covered investment on which the claim was being made, that covered investment had to be the one that was established in reliance on the investment agreement. There was nothing else that was in this requirement that we added. And this was done, our TPA provisions were identical. We were decided them right around the same time as we decided what would be in the model bit, and they are identical. So there's one other argument that I saw from Peru that I wanted to address, which is the argument that there could be, based on the reliance language, that there might be some temporal limitation for investment agreement claims in the TPA and any there could be any temporal limitation for investment agreement claims in the TPA. And the history behind this, in addition to the language, I think is very instructive on this question. The U.S. agreed. There was a substantial discussion about a temporal limitation in our initial post-NAFTA FTA negotiations with Singapore and Chile. And at that time, these provisions were new to them. They've been in other U.S. bits, but not to these countries. And their position was they needed some time in order to get their regulatory framework and contracts in place in order to be sure that they could accommodate investor-state arbitration over them. And ultimately, they insisted on having these temporal limitations. In Singapore, it would apply to any agreement from the time of entry into force. There would only be those investment agreements that would be covered. In Chile, they insisted on having only those investment agreements that were entered into 2 years after the FTA entered into force. And this was a make or break issue as far as getting investment agreements, and it seemed to us at the time in the U.S., so we did agree to that. But what we found was after we agreed to it, and also CAFTA was shortly thereafter, we agreed to something very similar to Singapore, our U.S. industry was very upset with the U.S. government for doing this, because they had many investment agreements that their companies had entered into for a long time that they felt it was critical that our FTAs cover. And as long as there was a breach, of course, after entry into force of the FTAs, they said it was absolutely essential for the investment agreement clause that would permit arbitration to have no temporal limitation. And as part of the compromise that included the scope of the agreement that I described a few slides ago, this was one other element that the U.S. interagency group agreed on, which was that going forward, there would be no temporal limitation. So in the TPA, that was our hard position, and other ones, Korea, Oman, Uruguay, Rwanda, after that, that was the same position that the U.S. took. In addition, with respect to Peru, we actually had concerns about potential breaches of Peru's pre-existing agreements derived from the actions of SUNAT. And that was another reason why in this negotiation it was very important to the U.S. not to have a temporal limitation. This matter was discussed, and on the left side you'll see the Andean proposal, which was just like what we had agreed to with Chile, that in the definition of investment agreement, it would be only those that took effect 2 years after the date of entry into force of the agreement. But the U.S. rejected that. It was very much a no-go issue. We did discuss it at length, but it was in that context where we discussed it. And you'll see, as in the bottom of the screen on the right, a clean agreement did not have this temporal limitation. And all of our discussion in this agreement, and in my recollection, any other agreement, because it was so clear that that's where it would be discussed in the definition of investment agreement, I do not recall any discussion that the U.S. ever had with either internally in the U.S. or with any other country where anyone suggested that the reliance requirement made would suggest that there was a temporal limitation that would apply because of that language. So that concludes my presentation, and I welcome any questions.
Thanks. So the first questions come from the respondent side.
Thank you, Madam President. We have some binders we'll be passing out. Wait a minute or two. Good afternoon, Mr. Sampliner. My name is Jennifer Hallworth McCandless, and I'm part of the legal team representing the Republic of Peru.
Good afternoon.
Good afternoon. We have met before. You may not recall, it was about 20 years ago, and we were representing a party in which we were discussing with interagency officials, and you were among those people, but that was, I think, about 20 years. I think it was 2004, so it was a long time ago.
I do remember.
Well, hello again. So I'm going to ask you some questions regarding your expert reports in this arbitration. And although I'll be speaking in English and you will be answering in English, as you may know, there is simultaneous translation ongoing. And so we should pause. I will try to pause in between your answers and my questions so that there is time for the translation. But don't take my pauses as an invitation to say more. I'm just trying to wait and be patient until the transcript catches up. And please listen to my questions carefully and respond concisely as you can, given that we have limited time in the proceedings. So initially, with respect to your first report, you state that you worked at the Treasury Department from October of 1998. Is that until 2019? Is that correct?
Yes.
And just to understand the employment timeline, you said in paragraph 1 of your first report that you served as attorney advisor through 2003. So I assume that you held that position from 1998 to 2003?
Yes.
And then from 2004 to June 2019 is the period of time which you served as the senior counsel at the Office of the Assistant General Counsel for International Affairs at Treasury, correct?
Yes.
And the only reason I ask is in looking at your the Appendix 1, which up to your first report, which contains your CV, you indicate that you held the position of senior counsel of the Office of Assistant General Counsel for International Affairs from October of 1998 to June of 2019. But that isn't actually accurate, correct? Because for part of that time you were attorney advisor.
That's a good point. I did that for brevity, and substantively there really wasn't any difference in what I did, but you're correct.
Thank you. And you state in paragraph 5 of your first report that you based your report on your personal experience as a negotiator of the agreement that became the TPA, correct?
Yes.
And during the time in which you were working and negotiating the agreement, did you take any notes or prepare any memorandum during those negotiations?
I took a lot of notes of those negotiations and prepared lots of emails at least.
And did you review those notes or memorandum before you prepared your expert reports in this arbitration?
No. When I left the government, I did not bring any documents with me from any negotiation I participated in.
So when would you say was the last time that you would have reviewed those notes or memorandum with respect to this, the TPA at issue in this case?
I think I did review them from time to time while I was at Treasury because, again, I was even known as someone who kept track of these things, so I did refer to them from time to time, but not since I retired.
So at least not since June of 2019?
Yes.
And you state in paragraph 6 of your first report that in preparing your report, you relied on, among other things, drafts of the U.S. Andean FTA and TPA, which you understand were obtained by a U.S. Freedom of Information Act request. Is that right?
Yes.
So you did not make the FOIA request yourself, is that correct?
I did not, that's right.
And you relied on claimant's counsel to provide you documents that presumably they made the FOIA request?
Yes, when I was retained, I was told they already had made the FOIA request and provided me documents that they had.
But given your experience in the U.S. government, and indeed you indicate in your CV that you had defended FOIA lawsuits both before you went to Treasury, not defending there, you were involved in FOIA litigation before you went to Treasury, and while you're at Treasury, you defended FOIA lawsuits, so I assume you're familiar with the FOIA process, correct?
Yes.
Did you consider making a FOIA request yourself to obtain some of the contemporaneous documents from the negotiations or meeting minutes or any other notes or memos that would support your assertions regarding the TPA interpretation?
I didn't. I know that for two things. One was that I was told by counsel for claimant that they had made a request for the entire negotiating record. And secondly, I know from my experience at Treasury that my status as former Treasury employee would not make any difference, and that I would not there'd be no reason to think I would get anything more from my FOIA request than counsel for claimant already received.
But you might have had more specific knowledge of exactly how to structure the FOIA request based on the documents that you knew existed, correct?
Theoretically, I think that's possible, but I think that looking in good faith at a request for the entire negotiating record was my former colleagues would have done that, and I'm not sure that I would have done any better than counsel for claimant had done.
Did you see the request that they made?
No.
You present 2 expert reports in this proceeding, correct?
Yes.
And you're presenting yourself as an expert on the issue of negotiations of the U.S.
I am.
You also state in your report that you were involved as a negotiator in the U.S. TPA, and again today in your indirect testimony, you're discussing in part your own personal experience while you're negotiating. So you are, as an expert on international treaties, but also you personally had experience in this TPA. Is that correct?
Yes.
But you're saying that you, in your second report, you say that you are basing your opinion on your years of experience drafting and negotiating international investment agreements, including this TPA. And you indicate that, but you also indicate that in your first report that the U.S. Trade Representative's Office was the lead agency in negotiations of trade agreements, correct?
Yes.
And so it was the USTR in this particular TPA that took the lead in the negotiations on behalf of the U.S. with respect to the investment chapter of what became the U.S.-Peru TPA?
They did. As a formal lead, I think in particular provisions, the Treasury took at least a co-leading role.
Let's discuss that, because you mentioned in your first report in paragraph 9 that Treasury has a leading role for all financial provisions in FTAs, and including taxation. Is that correct? And is that what you meant, what you were just saying? They take, Treasury had some kind of specific role in particular?
Yes. In taxation in particular, the responsibilities were divided in terms of the Office of Tax Policy would deal with any straight tax issues, or what's a tax measure, or anything that was really an issue of tax law. I was not a tax law expert, but I think they would rely on me as an expert on any tax issues that related to the exceptions, such as the exception for expropriation.
And you stated, actually today, you said you were personally involved throughout the negotiations, and I think you said you were involved in 3 of the, actually present for 3 of the rounds. Is that correct?
Yes.
And there were how many total rounds of negotiations?
I believe there were 13.
And where were the ones that you were participating in? Were they ones in Washington or?
The first one was in Atlanta, the round 2. The next one was in Washington, round 8. And the last one was it was called one round 13, but it was 2 different functional rounds in November, December of 2005.
So it's fair to say that you weren't physically present for 10 of the 13 negotiating rounds?
That's true. But as I'd also said, I was present for all of our interagency meetings as far as I knew, where we would discuss what had happened and what the U.S. position would be going forward for the next round.
And do you know Carlos Herrera?
Yes.
And when did you meet him?
I met him, I think I may have met him first in FTAA negotiations in late 1998, 1999, but I certainly met him, worked with him quite a bit during these negotiations, and then again a little bit in the TPP negotiations.
So in your reports, you state that in your first report, you say that your reports are based on your personal experience. You say that the report is based, your first one, your report is based on your personal experience as a negotiator of the agreement that became the TPA. And in your second report, you say that the report reflects your genuine beliefs concerning the matters described therein, correct?
I don't know if you're intending to distinguish the two, but I certainly wasn't when I said those things. Okay.
No. You also say that you do not purport to speak on behalf of the U.S. Department of Treasury or the U.S. government in preparing your reports, correct?
Yes.
So to be clear, when your statements regarding the TPA provisions in both of your reports, you're not representing the U.S. government's official position, is that correct?
I am not currently representing the U.S. government's official position, but I am recounting my recollections of what the U.S. government's official position was during the negotiations.
But you are saying that you are expressing your personal view and not that of the United States, correct?
In terms of any opinion, yes. And again, I'm not appearing as a representative of the United States, but I was a representative at the time in question, and so what I'm testifying about were when I was in that capacity.
Okay, but to be clear, because you stated in your second expert report in paragraph 2, I do not purport to speak on behalf of the U.S. Department of Treasury or the U.S. government preparing this report. So I take that to mean that, in essence, you are testifying in your personal capacity.
I am currently testifying in my personal capacity, yes.
Okay, thank you. And in your expert reports, you provide comments on and you did today here too, in your direct examination, you provide comments on various provisions concerning the TPA, correct?
Yes.
And in particular, you provided comments on the limitations period provision, and you did this also in your direct on the non-retroactivity provision, which you also did in your direct in the fork in the road provision, correct? And you also did that in your direct and the reliance provision, correct?
Yes.
And to confirm, we had just discussed, you stated that Treasury Department played a leading role with respect to all financial provisions in FTAs and those provisions, including taxation, correct?
Yes. To the extent I just discussed it.
Yes. But you didn't provide in either of your reports or today, indeed, in your direct testimony, you didn't provide any comments regarding Article 22.3, which discusses taxation measures, correct?
I didn't. And as I understand it, the issues in question don't relate really to the exceptions that I am an expert in, and they relate to the areas where our Office of Tax Policy would be expert.
Was it your choice not to discuss Article 22.3, or were you instructed by counsel not to discuss it?
I was asked to discuss the particular issues you've seen. I don't recall any back and forth between us about would I discuss this or not. And I think when I described my background to them initially when I was retained, I think I made pretty clear that I was not a taxation expert on taxation per se, other than with respect to, let's say, the expropriation exception.
So to be clear, claimant's counsel did not ask you to opine on 22.3 regarding taxation measures, even though you worked as a negotiator for Treasury, and Treasury played a leading role regarding all financial positions in FTAs, correct?
Correct, and Well, I don't know why they didn't ask me, but my guess would be that because I told them that other people had the expertise and were relied on as the key negotiators there. And I would just add that if people from that office were here today, they would emphatically confirm that they were the experts on this subject, and certainly at the time they would say I was not the right person to represent Treasury on pure taxation law measures and pure taxation law issues.
You think you did mention something about exceptions with respect to taxation, and you were involved in that?
Yes.
Have you seen the? Are you familiar? I know you're familiar with U.S. non-disputing party submissions because you've testified to that today and in your reports, and so clearly you know that those exist.
Yes.
In your view, are those submissions are the official word of the U.S. government on those provisions that they discuss in the submissions?
Yes.
Have you seen the U.S. non-disputing party submission in this case?
Yes.
And with respect to Article 22.3, you're familiar that the U.S. says...
Objection. This is not a provision that the expert has opined on, as counsel has just established. So I can't see any legitimate purpose in asking the expert about the U.S. position in the non-disputing party submission on this clause.
Well, he is testifying as based on his experience working as a negotiator of this
I'm sorry,
TPA.
Section 35 of PO4 is very clear that the expert will not be cross-examined on matters beyond the scope of their expert report. So I can't see the possible...
His expert report concerns his negotiations, the negotiations of the U.S. With respect to the TPA, which he was involved in, and he went through a great length of telling about his experience with respect to that negotiation. It's completely within the scope.
Yes, but we're talking about a specific provision, the tax exclusion, which the expert did not testify about in his expert reports or today during his direct presentation, and which counsel has just gone to great lengths to establish he did not testify about. So it cannot possibly be permissible under Section 35 of PO4.
I would have also asked you the question whether you were involved in the negotiations of this provision, but I understand you saying no, it would have been a different colleague from the Office of Tax Policy, right?
Well, when you say this provision, it has exceptions. So I was involved in negotiations of the exceptions under the provision, but not the pure tax issues.
Then we can come maybe to this point later, and the tribunal may have questions on this point.
I was just going to ask, in his professional experience, based on his experience negotiating this TPA in particular, if he agreed with the U.S. in paragraph 32.
Yeah, that's the exact question that we object to.
Yeah, and I think we've just determined, he said he's been discussing his entire negotiation with as a representative of the United States in the TPA, and he just said he did have information about the exceptions of taxation, and that's exactly what this question goes to. I think it's completely within the scope of his expertise to answer the question, which is a very specific question.
Yeah, that's not the standard in PO4. The standard is matters that were covered in the experts' reports or direct testimony.
He has been testifying today about his experience as a negotiator, and this is part of that negotiation, so it's completely within the scope of his testimony. If not in his report, and today when he is discussing the scope of his experience as a negotiator on this issue.
He has been testifying that he would not have been the person negotiating this provision, and that it would have been his other colleagues at Treasury that would have the expertise to discuss that provision.
Madam President, he just clarified that wasn't the case with the expected exceptions, and this is an issue of exceptions.
Now to get this discussion cut short, so on which provision in this protocol you rely when you say you object to this line of question and the testimony of the expert?
I'm sorry, Madam President, are you referring to the privilege protocol?
So what is your, or your PO4, whatever you refer
PO4,
to?
Section 38 of PO4.
Can you maybe put it on screen because I do not have it here at my desk?
But I can just read it into the record. It does say the adverse party may cross-examine an expert on matters that were addressed or presented in the expert report or during direct examination or presentation.
And my response to that is he did discuss his negotiations of this TPA in his direct presentation very extensively, and therefore it's completely within the scope to ask him a question about this issue, which he has already stated is actually within his scope of knowledge, even if it weren't within the scope of his knowledge as being an expert, which of course it would be.
That can't possibly be the standard. She's asking the expert about a specific provision, Article 22.3.1, which she first established that the expert does not have expertise in and was not involved in negotiating in the TPA.
And then he just corrected that and stated that he did have that knowledge.
No, he said that he had experience with 22.3.6, which is the exception to the tax exclusion.
This is relevant to that issue.
No, because the U.S. does not discuss that provision. The U.S. only discusses Article 22.3.1 in its non-disputing party submission. So asking the expert whether he agrees with the U.S. non-disputing party submission could not possibly be relevant to the exceptions to that provision.
Please rephrase your question. We want to come to the core of his testimony, and we had the same debate earlier on when Mr. Prado raised some question, and he also insisted it's the core of the testimony. So to ask the expert on his involvement in the negotiation is certainly proper, but what you have just raised, I think, is correct. It cannot be related to the non-disputing party submission.
Yeah, and we'll just add that asking the expert about provisions that he did not testify about couldn't be further from the core of his testimony. So we would just submit that the PO4 should be followed and counsel should stick to cross-examining the expert on matters he testified about.
Madam President, what he testified about, he is as a negotiator and he had experience with respect to this negotiation. Therefore, the fact of what he includes or doesn't include is certainly relevant within the scope of his testimony. Well, I will just, if you've had, well, all right. Well, I note that he has not, as a matter of fact, then testified on an issue with respect to taxation measures, notwithstanding the fact that he is the part of Treasury, which is the lead negotiating agency and lead role with respect to taxation in the TPA, which in and of itself says...
Counsel is testifying. Is there a question?
I think and now we change it a little bit, and maybe you can talk with me for a moment. The tribunal is permitted to ask questions at any time, and in order to discuss procedural objections on cross-examination, I would like to be educated by you as an expert on the exceptions to the tax exemption. So maybe we can put the a specific provision 22.3 on the screen and the exceptions, and then you can just educate me on what you can give your expert testimony or on what not. So if we look at this Article 22.3, with what provisions or on what provisions were you involved in the negotiations?
Okay, I wasn't involved in either paragraph 1 or paragraph 2. I was occasionally involved. Paragraph 3 and 4 on the NT-MFN, that was one of joint responsibility between me and my colleagues in tax policy because it involved some tax issues and some investment issues. And then I think you'd see paragraph 5 and 6 were ones. 5 relates to performance requirements, 6 relates to expropriation and investment agreements, and I was very much involved in those paragraphs.
But do I understand
They
you
aren't on the
correctly that
screen.
in what
I'm
were you
describing-
involved in fair and legitimate expectations, or
I don't even see legitimate expectations, but so paragraphs 5, which relates to performance requirements, and 6 on expropriation and investment agreements were the main ones that I was expert on. And I was just saying above that paragraphs 3 and 4, which pertain to national treatment and most favored nation treatment, where they had mixed investment issues and tax issues. So often on those paragraphs, our tax people, you'll see various types of tax measures described on purchase and consumption of services and generation skipping taxes and the like. And we would need our tax experts to talk about that. But in talking about national treatment and some of the subparagraphs, I would talk. So that was just a joint responsibility. But it just was paragraphs 3 and 4 were joint responsibilities between me and my tax policy office counterparts. 5 and 6 were primarily me as the expert. Paragraphs 1 and 2 were the tax policy people, were the experts on that.
and let me just ask a simple question. My understanding of the parties' submissions or some positions was that arguably we as a tribunal have jurisdiction if the breach of an investment agreement is at stake, even on questions that are then taxation measures. So now if, as a consequence of this alleged breach of the investment agreement, specific taxes have been charged which are stabilized or not, whatever, we have jurisdiction nevertheless to decide. Is this your understanding of the provisions as well, or do I misread something in the TPA?
That is my understanding. I just thought, though, there is a question, and I thought that the U.S. non-disputing party submission related to the question of what was or wasn't a taxation measure. And that's a Article 22.3.1 issue.
Exactly, but taxes are certainly a taxation measure.
Right.
And nevertheless, my understanding is, as long as a breach of an investment agreement is at issue, we can or have jurisdiction to decide also on this tax consequences of the case. Is my understanding correct? Is this your expert testimony?
Yes, and I would say anything that is discussed in paragraph 6 about the coverage of investment agreements is something that I could testify about. But the question, if the question is, what is a taxation measure, which that term is used in these paragraphs, but the way it is defined and the question of who negotiates it is, that's the Office of Tax Policy. And that actually, and maybe this would help, in the negotiation of these, of all of our free trade agreements, there would be an investment group, and we would discuss the investment issues and things like what kind of tax measures might be an expropriation, or even to what extent investment agreements are covered. We would discuss that in our group, but the tax part in Article 22 generally was a completely different group that I hardly ever attended. And that's our Office of Tax Policy would be the people who would talk about the general coverage and particularly paragraphs 1 and 2, as well as 3 and 4.
This is understood, and I will
Okay.
definitely not ask you on now these text specificities. But one other question I would have, and please let me know whether you can testify on that or not. So we address the issue when an investment agreement is breached, we are competent, have jurisdiction, also decide on taxation consequences, whatever claims that are related to that. But on the alternative claim of the claimant, which goes on the assumption it's not the breach of the investment agreement, it's a breach of other provisions of the TPA. And if in this context of this alternative claim, breach of customary international law, for example, we come across a clear taxation measure. It's about whether the taxation regime applied, stabilized or not, or whatever. Are we still competent? Can you testify whether, in your view, we have still jurisdiction to decide on these taxation measures included or being part of the claim?
Well, I could say that part of your question addresses whether minimum standard of treatment claims can be raised with respect to a taxation measure. And on that one, the article makes, I think, pretty clear that because paragraph 1 says all taxation measures are excluded unless listed below, and minimum standard of treatment is not listed below, we would say that if it is a taxation measure, that minimum standard of treatment with regard to that measure is not covered. That we would even talk about in the investment group. But whether it is a taxation measure in the first place is the question that our tax policy people are the experts on.
Thank you very much. This was very clear, and so please respond and continue with your question.
Thank you, Madam President. You said that the tax policy people would be the ones to discuss a taxation measure. And when and you're familiar, we had just discussed about U.S. non-disputing party submissions. If for putting together a U.S. non-disputing party submission, would those tax policy people have been consulted?
Sorry, I lost your question somewhere. Could you repeat it?
You said that the tax policy people are the ones who would have worked on the definition of taxation measure. And I'm asking that if in putting together U.S. non-disputing party submission on that issue, would they have consulted with those tax policy people?
Probably, yes. And in my experience, I remember they would normally, the State Department would go to me, and then I would, if the question was whether it was a taxation measure, I would then go as the interlocutor to our tax policy people, but the substantive discussion would be between the tax policy people and the Office of Claims and Investment Disputes at the state.
Thank you. Thank you. I have no further questions.
Concerning the taxation issue, and I understand you have not negotiated, and I don't know how much can you speak about this in particular, but both in the main claim and in the alternative claim, there's a discussion about royalties, and royalties have not been considered taxes by the Peruvian Supreme Court. Has that any impact on the issue of 22.3? I mean, what are we speaking about by taxation measures?
I think you are getting into an area of depth way above my head on that one.
Okay, thanks.
You have discussed in your presentation about the fork in the road, Article 10, 18.4.
Yes.
You are aware that Cerro Verde went through different administrative courts and judicial courts in Peru going into the Supreme Court. The fact that the Supreme Court has decided something, to what extent it's in contradiction with this article, and to what extent the decision of the Supreme Court of Peru interpreting Peruvian legislation is somehow very relevant to our decision.
I think that in looking at this article, 10.18.4, the question is not really what any court decided, but rather what the cause of action was that was presented to them. And we certainly, in our fork in the road, never thought or suggested or stated that the fact that a particular issue is ultimately resolved by a court has relevance to the question under the fork was simply whether this same breach was alleged in the first place in the courts or administrative tribunals or other dispute resolution proceedings. And so that would be the question. And so ultimately, I just don't think I see much relevance to the fact that if a different cause of action is being brought and a court ultimately decides on that court of action, there might be a question of deference to that court's decision. I'm sure there would be that kind of question that might be raised, but it isn't a fork in the road question.
We might be obliged to enforce Peruvian law, and the question decided by the Supreme Court is either the concentrator is covered or not by the stabilization agreement, and they have decided it's not covered. To what extent it's really the same cause of action we are discussing here?
I'm might have lost the thread of that question, but perhaps this would help. Is we would discuss issues such as, and I remember with the Chileans and some other countries, we would discuss the question of that they would raise to us that let's say Chile would say we have the same expropriation law in substance that that is in the FTA, and that ultimately we don't want the FTA tribunal to rule on something that in substance is the same as the Chilean court would rule, and this could overturn the decision of the Chilean court. And our answer was that at least the fork in the road was only intended to preclude, in that case when we were discussing treaty claims, because the only fork in the road question was, are you taking the same bite out of the same apple as in the other proceeding as you are in the TPA proceeding? And if you are, that was something that should be precluded from the outset. If you aren't, and then brings up other questions of the extent of deference and res judicata, collateral estoppel, and the like, but those are questions under those doctrines and not questions under the fork in the road article. Not sure if that answered your question, but if not, maybe I didn't understand your question.
Well, not totally, but thank you very much.
Okay.
I have another question relating to 10.16.1 and 10.28, the reliance. I heard you stating, and it's also on the bottom of slide 6 of your presentation, investment agreement claims are permitted if either the claimant or the enterprise relied on the agreement. Does, in your view, our jurisdiction require proof of reliance, or is it the claim of reliance that is sufficient to establish the jurisdiction of an investment tribunal under the TPA?
I think that in any jurisdictional issue, my basic understanding is along the lines of, I think, what the U.S. would say is that it is the burden of the claimant to establish every jurisdictional condition. So to the extent that the reliance is necessary to have jurisdiction, then it would be the burden of the claimant to show that either the investor or covered investment had relied on that agreement.
Thank you. So we turn to claimant now.
Thank you, Madam President. Just one very brief question on redirect. Mr. Sampliner, thank you. You were asked by Ms. Hayworth McCandless about what you relied on in preparing your expert reports, and also about whether you know Carlos Herrera. Do you have any views about the available record of TPA negotiations in this case, including given your knowledge of Mr. Herrera's testimony in this case?
Right. I did hear his testimony, and I was struck by the testimony he gave that there were reports from, I think, 4 different agencies on what happened in each of the 13 chapter negotiations, and was surprised to hear that, as I understand it, those had not been produced in the arbitration.
Thank you, Mr. Sampliner. Nothing further.
Any follow-up questions from the respondent?
No follow-up questions. Thank you.
Then this concludes your testimony. Thank you very much. You are released with thanks.
Thank you.
Shall we make a short break or simply continue? Then we do our break now and then we continue. Welcome back and good afternoon, Mr. Otto. You have been nominated by claimant in this proceedings as expert. I briefly introduce the tribunal members. To my left is Professor Tawil, to my right Dr. Kremades. My name is Inka Hanefeld. I'm the presiding arbitrator in this case. Before we turn to your expert reports, under Rule 35.3 of the exit arbitration rules, you are requested to make a declaration that you will testify in accordance with your beliefs. Can you please read this declaration out for us?
Declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. Then let us turn to your expert reports. Do you have your reports CER 4 and 9 in front of you?
No. These are Gary Simpler's. Sampliners, excuse me.
Yeah, wonderful. Then we have identified an issue to solve. So often my questions are obsolete, but at least now we know why I asked them. So please, and I'll give Mr. Otto the opportunity to have a look at his report. And the next question, will you give a presentation?
Yes.
Has it been already circulated to Professor Tawil? Everyone has it, perfect. So now another look to your expert report, CER 4 and 9. Do you have them now in front of you?
Yes.
Perfect. Can you confirm that these are your expert reports?
Yes.
Do you have any corrections to make, or can you just start right away with your presentation?
No corrections.
Then please go ahead with your presentation.
Over the course of the next 30 minutes or so, I'd like to talk a little bit about mining fiscal stabilization. Before I get into the report, let me tell you a little bit about myself. I'm a mineral economist and mining lawyer, and I've got over 40 years of experience. I've worked for governments, the private sector, and multilateral institutions. I've been engaged by governments in over 30 countries to assist in drafting their mining laws, agreements, and mining policies. And I've assisted over 40 countries in the development of their mineral sector fiscal strategies and policies. And this includes almost all of the major copper producing countries that compete with Chile for investment and with Peru for investment. I was engaged by the Peruvian Ministry of Economy and Finance in 2002, and I prepared a comprehensive review of the Peruvian mining tax system, and I provided recommendations to government, many of which were incorporated in the Peruvian laws subsequently, mainly in 2004. In 2011, I was called back to Lima by the ministry and prepared a report on mining royalty reform options, and met with the various officers, politicians, and the President's office on my findings and recommendations. And again, they adopted some of my primary recommendations a year later. In my talk, I'm going to cover 6 topics. I'll start with this brief overview. Then I'd like to delve into terminology before talking about how governments offer stability to an entire mining unit, entire mining project to attract continued mining sector investments. Then I'll briefly discuss how countries that Peru competed with at the time for investment offered to stability guarantees to their mining units as a whole. I'll then talk about how Peruvian law and practice was consistent with international practice before coming back to my conclusions. A key question, I think, that we have here today is, do stability guarantees apply to an entire mining operation? And it is my belief that comparative practice in competing nations can help answer this question. The conclusions in my report are that comparative practice shows that stability guarantees apply to mining units as a whole, that Peru competed with jurisdictions that applied stability guarantees to mining units as a whole, and that the SMCV's operation, its leaching and concentration facilities, are part of the same integrated mining operation, the Cerro Verde mining unit, and that there was nothing in the Peruvian law and regulations at that time that would alter the presumption that stability guarantees applied to the entire mining unit, and that restricting stabilization to operations described in an initial feasibility study is illogical. It fails to recognize that large mines continually evolve and is counter to the primary purpose of providing stabilization, which is to attract continued investment into the mining sector. First of all, terminology. An integrated mining operation is a common concept in international mining practice. In my reports, I use the term mining unit, which refers to a single integrated mining operation. Now, what do I mean by that? A single mine that shares supply, administration, services. The term for integrated mining operation varies from country to country if you take a look at their laws. And it's often not even defined in the law. Sometimes it's referred to as a mining project, a mining operation, an economic mining unit, a mine, or a project. In Peru, the term that they use is mining unit, economic administrative unit, single production unit. They all convey the same concept of an integrated mining operation. And why is this important? Because comparative practice is that stabilization applies to an integrated mining operation, and Peru's practice was consistent with this. Why isn't the term mining unit defined in the legislation? Well, having drafted mining laws for many nations, I have first-hand experience in deciding which terms get definitions and which do not. Basically, terms that will have a narrower or different meaning than what a professional, such as a mining engineer, would understand the term to mean, those are the ones that get a definition. I don't believe that a mining engineer would have any trouble understanding what is meant by the law when they refer to a mining unit. It refers to an integrated mining operation. Why do miners seek stabilization? Well, it's to reduce their risks, which are very substantial. First of all, operations evolve. There will be changes to initial assumptions, for example, about limitations on water, power. Most large mines make substantial investments after initial construction, and it would be difficult to identify a major copper mine anywhere in the world that is not evolved to take into account the varying nature of its ore body, infrastructure development, technology. All the mines I talk about in my comparative analysis report had continued investment, including Cerro Verde. Mining companies know that they're going to be making continued investment in their operations and need to know that that's going to be stabilized. I am not aware of any country, anywhere, where a company is required to get a written confirmation that stability applies to new investment in a stabilized mine and that it's required to get some sort of written assurance that it does. No country. Coming back to risks, mines have high capital costs. There's a lot of money at stake. Many hundreds of millions of dollars, often billions of dollars today. Mines have long payback periods, 8, 10, 12 years often. And large mines are financed through loans. And lenders will want to see fiscal stabilization during the loan period to reduce inconvertibility and withholding tax risks. Mines are also immobile. If the government changes the rules of the game, you can't just pick the deposit and mine up and move it to another jurisdiction. Mines are also subject to commodity price cycles. This is a graph that shows copper prices and molybdenum prices over time. And when prices go up, so does the risk that governments will raise taxes and investors seek stabilization to mitigate this risk. You can see here in around 2002, the copper price took off and really peaked around 2012. During this time period, I received numerous requests from governments to take a look at their tax systems to see how they could get a bigger piece of the pie. Now, most of them were getting a lot more money. Obviously, prices went up, income taxes went up, withholding taxes went up, so their tax take did go up, but they wanted a bigger piece of the pie. If we take a look at this graph, Peru introduced a new royalty in 2004 after prices began to rise, based perhaps on my 2002 report for the MEF. And as prices began to rise even further, a lot of political pressure was brought to bear in the country, and various senators developed various bills to raise taxes on the mines. I was approached by the MEF to come back to Peru to take a look at some of these bills and to model them for the government, and I did. And I prepared my report and recommendations in a report in 2011, and in 2012 the government changed its approach to royalty. In summary, with regard to risks, investors seek stability for their entire mining project to protect against fiscal and administrative risks for all of these reasons. I'd like to talk a little bit about the countries that Peru competed with for investment. During this time period, much of the world, you simply could not invest in it. Places like Russia and China just closed. The former Soviet states and Eastern Europe, you could not invest in those places either. They were in transition. Other countries, like Iran and Afghanistan, had big copper deposits, but politically, you could not go there or there was war. Several other countries had big copper deposits, but they had restrictions in place, such as requirements for majority equity ownership held by government or by nationals, and this simply was not acceptable to most mining sector investors. So with regard to copper, these are the countries that you could invest in. This is where the action was. My reports conduct a comparative exercise with all of these jurisdictions to take a look at how they approached stability. And you can see the list on the left. In taking a look at their systems, and I have experience in all of these countries, all extended fiscal stability to an entire integrated mining operation. All provided stability to continued investments in mining operations covered by an existing agreement. The purpose of feasibility studies for stabilization purposes was to establish that a minimum threshold was met. That might be an amount or a quantity of capacity. With regard to feasibility, it just doesn't make sense that a government would limit stability to only a point-in-time project when it knows that the mine's going to continually evolve, investing new money year by year. And it's not realistic to expect that every new thing you add to a mining project that's not set it out in a feasibility study, say a new crusher or a conveyor belt or a new processor, may be subject to a different tax regime. It just doesn't make sense. That's just not the way it was done. I found nothing in the Peruvian mining law and regulations that would alert an investor that the Peruvian approach differed from these findings. Now, the process by which stabilization was granted varied from country to country, but the result was the same. I'm going to give you just one example today. There's others in my report. This is Chile. Chile uses a statutory informed contract approach, in some ways similar to Peru, but it's done under a special foreign investment law, not under the Mining Act. The contract grants stability for a company's expenditures on activities in an area. And in my report, I provide reference to the Candelaria project, big copper mine, contemporary with Cerro Verde. And it covers all the mining activities during the term of stabilization. Just a typical example. In my experience, Peru looked to Chile because of its success in attracting investment into its copper sector. And in Chile, the concept was clear. Stability applied to a company's entire integrated mining operation. Again, the approach to stabilization varied in each country, but the end result was the same: stability for a defined time period for an entire project. Stability agreements in Peru are not negotiated. The mining law and regulations set out the stability benefits that are available to every mining company that meets a threshold, and a form adhesion contract is used. In my opinion, this is a good approach because it's efficient, eliminates bureaucratic discretion and corruption, and makes administration and supervision transparent and effective. An investor that meets the procedural requirements is entitled to a standardized stability agreement. There's no negotiation, no cost-benefit analysis, no restrictions on future investment. This is reflected in Mining Law Articles 72 and 86. Peru obligates itself to enter into a non-negotiated form stability agreement with any mining company that submits a feasibility study demonstrating that it will meet the minimum investment requirements. Regardless of the approach, the end result is the same in each of these jurisdictions. The entire mining unit is stabilized. In my view, Article 2 is the key scoping article in Peru's mining law, and it indicates that stabilization applies to an EAU. This is Peru's way of saying integrated mining operation. Article 82 establishes the concept of an EAU as a single production unit sharing supply, administration, and services. And I'd like to illustrate what this means in the next several slides. This EAU definition is consistent with the concept of an integrated mining operation globally. What do they mean by shared supply, administration, and services? Well, we've got upstream activities, exploration, mine planning, extraction of the ore, trucking the ore, and various plans that are prepared on an ongoing basis. You've got operational activities, things like administration, employment, electricity supply, water supply, transport, downstream activities, things like sales, marketing, logistics, and EAU. All of these shared costs are associated with a typical integrated mining project, an EAU, and they're not attributable to any single part of the operation, such as an individual processing plant. Let's take a look at Cerro Verde, which, like other examples I provide in my report, is one of the world's largest copper mines. It's obviously a single integrated mine. It operates a single mine, single point of ore extraction. Operations are coordinated from a mine office. If we take a look at the figure on the left, you can see the mine pit and the various processing plants, in plural. If you take a look at the figure on the right, this shows infrastructure that's shared by the various processing facilities, including things like water, power, roads, security, etc. Any mining engineer, whether from Peru, Chile, or Indonesia, would agree that this is an integrated mining operation, a mining unit. This is a picture of the ore body. On the figure on the left, we can see three types of ore. The green are the oxides that you've heard about, the red, the secondary sulfides, and the yellow are the primary sulfides. You can see all these different ore types. The lower dotted line shows the eventual extent of the mine pit, after which new investment will be required in order to move underground. The ore types overlap each other, and depending on its attributes, your ore will be sent to one of the various processing plants. The ore body is part of the integrated mining operation, just like the processing facilities, some of which use leaching and some of which use concentration. Wide-space drilling is done to obtain data about the ore, and each year a conceptual plan is developed for the next year using a block model, and that's what you see on the right. This is a picture of the mine pit. Where ore will be delivered is decided pretty much on a daily basis. The little holes you see on the right there, well, those are for blasting, and samples from the drill hole are assayed to determine the nature of the ore. Based on those assays, waste rock is taken to a waste dump. Low-grade oxide is taken to a large material leach pad. High-grade oxides to a crusher facility and then to a leach pad. Secondary sulfides, they go to a leach pad or concentrator. And the primary sulfides, they go to the concentrator. According to the other expert reports that I've read, if the two concentrators had not been built, a lot of the oxide and secondary sulfide ore would not have been economic to mine. As you can see from these slides, there are not two operations. There's not a concentrator and a leaching facility. It's an integrated operation. Cerro Verde is an EAU, in the international mining lingo, an integrated mining operation. If you're interested in learning more about the mining operation and why it's integrated, I highly recommend that you read Ramiro Acuero's witness statement. He goes into a lot of detail. That's where I got most of this information. He's the chief planning engineer for the mine, and he has a superb description of the mine's operations, which clearly show that the mine has never been conceived of a static investment defined by that initial feasibility study.
Mr. Otto, a question on the
Yes.
picture. Is it the sulfides already seen here? Are those in the bottom, or where would be the, I mean, the sulfides, if I understand correctly, are on the bottom of the, and are they already seen here, no? Where they take the sulfides from? No.
Well, what they do is, what you see there are, the mine is developed with benches, those layers. And as they mine each bench, they have to break the ore up. And they don't know what that ore is in advance. They have a general idea because they have these wide spaced holes. But each day, they will drill these holes, they'll prepare a section to be blasted. They'll then assay samples. That'll go to a laboratory, and they'll say, oh, this section right here is sulfide. This section over here is oxide. It's not like there's distinct layers
so
like this.
We would not be able to see this in the picture. It would depend on the,
Yes.
on the lab. Okay,
Yes,
thanks.
it would be the assays. And it's all mixed up. You have a column here that's one, a column here that's another. So you really don't know. It's the ore grade is mixed up.
Understood. Thank you.
Okay, moving on. The Peruvian approach was consistent with international practice, and I'd like to talk just a minute about ring fencing. Nations that offer stabilization usually ring fence each stabilized integrated mining operation, and that's the case in Peru also. Ring fencing is where a company that operates several mines must keep separate books of account for each mine. For example, an investor may have started one mine in 1990, and 20 years later, another mine in a different location. If one of them is stabilized, they're going to have different tax systems. Since two respective stability agreements would stabilize different tax regimes, each mine would need to be taxed separately. Like in other countries that offer stability, Peru has taken a similar approach. Operations in different EAUs are calculated separately. Ring fencing is addressed in Article 22 of the mining law. Article 22 says that a mining company that has different EAUs must keep separate books for each. The article includes information how shared costs can be attributed for tax purposes where there are two or more EAUs. But this does not apply to Cerro Verde because it's a single EAU according to the definition in the mining law. This is the same approach that other countries use. I'd like to briefly talk about separating costs. There is a presumption that stability applies to all activities with an integrated mining project in EAU, and there's no reason to allocate shared costs. However, if separate tax systems apply, the division of shared costs for determining taxes would be inherently arbitrary, uncertain, and discretionary. And Peru did not provide any guidance on how shared costs should be allocated. I'm a tax policy expert, and good tax policy aims to provide certainty and predictability. If a government is going to require a taxpayer to allocate costs within a mining operation, it should provide detailed guidance to taxpayers. There's a fundamental taxation policy, principles of certain and predictability. Calculations need to be clearly defined. As I mentioned before, after the huge rise in copper prices and after the introduction of numerous bills by senators, I was invited back by the Ministry of Economy and Finance to analyze bills and make proposals. One of the bills prepared by a senator would impose individually a type of tax on each type of metal produced by a company, taking into account revenues and costs attributable to that metal. This would have been an approach that would have required allocating shared costs in some instances. And in this slide, you can see my advice to government. It is my understanding when the government decided that Cerro Verde's concentrate and cathode production would be subject to different tax systems, it did not provide any detailed guidance, violating the fundamental tax policy objective of certainty and predictability. Peruvian practice with regard to stability was consistent with international practice. I reviewed the testimony of the Director General of Mining, who was in charge of stability agreements, and that of the author of the Consolidated Mining Law. You've heard their testimony. Their opinion was that the scope of the stability agreement extended to the entire integrated mining unit, and that's in accord with international practice. To me, the Peruvian mining law encourages mine reinvestment, and that stability applies on an EAU mining unit basis. Reinvestment tax schemes are not all that common, and obviously Peru wanted to continue to expand and invest. The government approved the application to expand the existing beneficiation concession, and like other countries, made no distinction between leaching and concentration. If the government did not intend to extend stabilization to the concentrator, why didn't it require SMCV to apply for a separate beneficiation concession? During my many meetings to prepare my comprehensive review of the Peruvian mining fiscal system for the MEF, a limitation of stabilization to only the initial feasibility study never came up. It was a non-issue. No one was thinking that way. It would have been a unique position worldwide, harming Peru's ability to compete for investment. The concentrator application was not the first time that Peru expanded the beneficiation concession. Here you can see on this slide all the various changes that took place. In 2002, SMCV expanded the capacity of its beneficiation concession by around 30%. This expansion was never contemplated in the initial feasibility study, but represented a new investment. The government honored the stability agreement with regard to sales from these prior expansions in line with international practice. These expansions are the type of continuing investment that are typical of all large copper mines. Finally, my conclusions. Comparative practice shows that stability guarantees apply to mining units as a whole. Peru competed with jurisdictions that applied stability guarantees to mining units as a whole. As a whole, SMCV's leaching and concentration facilities are part of the same integrated operation, the Cerro Verde mining unit. There was nothing in the Peruvian mining law and regulations that would alter that presumption. And restricting stabilization to operations in an initial feasibility study is illogical, and it fails to recognize that large mines continually evolve and is counter to the primary purpose of providing stabilization, to attract continuing investment. In my over 40 years of experience in over 60 nations, this is the first time that I've seen a government try and limit stabilization in the way that Peru did following the completion of Cerro Verde's $800 million investment. I urge the tribunal to reread my first report if they want additional details, in particular paragraphs 15, 31, and 34, 31 through 34, which set out my main conclusions in reasoning. Thank you.
Thank you very much, Mr. Otto. Respondent will now make the cross-examination.
Thank you, Madam President. Good afternoon, Mr. Otto. We have seen each other before. This is a case of repeat.
Deja vu.
Deja vu, exactly. And some of the questions will be familiar to you, and some will be different. But because this is a new tribunal, it's important to address the issues before this tribunal. And as in the Cerro Verde case, and as you are testifying in English and I am speaking in English as well, we'll just have to pause between our statements so that we don't, so that we're allowed to have the simultaneous translation into Spanish. And thus, if I pause after a question, I'm not necessarily, or after you testify a little bit and I ask a question, it's not necessarily I'm inviting you to continue to speak. It's a matter of just waiting for the translation to catch up. And in light of the fact that we are limited in time, I ask that your answers you provide, they be short so that I don't have to interrupt you, which wouldn't be pleasant on my part, from my end. So to go over briefly your background, you state in your first report that you're an expert in mining law and taxation, correct?
Correct.
And you have 40 years of experience, or over 40 years of experience, in the study and practice of natural resources law and mineral economics on behalf of governments, the private sector, and multilateral institutions, correct?
That is correct.
And you were a research professor at the University of Denver's School of Law for about 12 years, from 1996 to 2008. Is that right?
That's correct. That's correct.
And
director of the Natural Resources Law Program.
Okay. At the University of Denver.
Correct.
And for about 4 years, from 1992 to 1996, you were a senior lecturer at the University of Dundee's Center of Energy, Petroleum, and Mineral Law and Policy. Is that right?
Yes. That's the largest natural resources law program in the world. I was also acting director.
And you have worked as an independent contractor advising governments on natural resources law and economics, correct?
That is correct.
So for your professional career, you have been a professor and served as a consultant for governments on natural resources law and policy. Is that right?
That is correct.
And I didn't see on your CV, and I didn't see in your opening presentation, your direct presentation, that you have any experience working for an accounting firm. Is that correct?
That is correct.
And you didn't mention anything in your reports which indicates that you have ever advised private mining companies on how to file their taxes, correct?
No. I have not advised companies
not.
on filing their taxes.
Just to be clear.
Just on strategies of where not to invest based on tax matters.
Thank you. And indeed, you stated in the Cerro Verde hearing that you had no accounting experience and that you never advised private mining companies on how to file tax returns. And that, if we have that, it's day 7, page 1, 1941, lines 9 to 13. The question was, and I don't, similar to what I just asked, I don't recall you saying in your direct presentation, nor do I recall seeing in your reports that you have, or on your CV, that you have experience working for an accounting firm. Is that correct? And you answered, no accounting experience. And I asked, and neither have you said, either in your direct presentation or in your reports, that you have advised private mining companies on how to file tax returns. Is that correct? And you said that's correct. And then I further asked, is just to confirm that your earlier answer, you yourself you don't have any experience preparing or advising mining companies on how to prepare tax filings. Is that correct? And you answered, that is correct. And I assume you confirm those answers today?
Yes.
Now, you state in your reports that stability guarantees presumptively apply, and you mentioned this in your direct testimony today as well, to an entire mining unit. So I first want to discuss the allegation of a presumption that you mentioned. And in your reports, you give examples of a limited number of jurisdictions in the world that you assert provide stability benefits to all investments within a mining unit. But you don't cite in your reports, and you didn't state in your direct testimony any support for the general idea of the existence of a worldwide presumption regarding the scope of stability agreements and that they presumptively apply to mining units. Isn't that correct?
No, I would say it's not correct.
You cite to something in your reports?
Well, my report cites examples of every major copper producing developing country that, with the exception of Mexico, and they all provided stability to the entire mining unit, including new investments. So when you say you don't cite, well, I've got all the citations demonstrating that each of these countries, they provided stability to the entire integrated mining operation, including new investments during the period of stability.
Well,
those are very specific sites.
Yeah, let's take a look at some of when you make a certain assertion. So in paragraph 15 of your first report, you make an assertion, governments presumptively apply stability benefits to all investments within a mining unit, and you don't cite anything in that statement, do you? You don't have a footnote there,
No,
do you?
not in that statement, no.
And then if we turn to paragraph 32 of your first report, we'll put that on the screen momentarily, 32. And you assert there, all of the stabilization schemes that I am familiar with are granted to either the mining company or a mining unit of that company without regard to the content of the feasibility study that it initially submitted to secure a concession or stability benefit. And you say, I am not aware of any jurisdiction law or agreement that grants stability to just part of the activities performed in the within a mining unit. For that first sentence in particular, you're not citing to anything there, are you? Like citing to a particular document, correct?
No, not there, but as I mentioned, each of the examples I provided, I did the research, and you've got the citations that demonstrate that.
We'll get to the examples that you provide in a minute. I just want to look at what the statements that you make in your report and whether you provide a citation with respect to supports for that. So you do mention 7 countries on which you relied. Is that what you're talking about? The 7 countries you relied in your survey, and you identified that in your direct testimony as well. You referred to, on slide 11, you referred to Argentina, Chile, Democratic Republic of the Congo, Indonesia, Mongolia, Papua New Guinea, and Zambia, correct? Those are the comparative jurisdictions you analyzed.
Yes, which I selected because they are the countries that Peru competed with for investment during that time period.
And you, as we discussed at the beginning of this cross-examination, that you've studied and practiced natural resources law and mining economics on behalf of governments and the private sector for over 40 years, correct?
Yes.
But based on that, you weren't able to identify any independent authority who agrees with your theory of a worldwide presumption that stability benefits apply to all investments within a mining unit, correct? You're citing to your 7 comparative studies that you did, but you're not citing to an independent authority which agrees with your theory of worldwide presumption that stability benefits apply to all investments, correct?
This is a pretty narrow field. There's only a few people who write about it, myself being, the primary author of most of the texts on it. So there's nobody to go to cite, really.
So it's your theory of the presumption, of the worldwide presumption.
Well, I do provide...
So it is your theory that there is a worldwide presumption, correct?
Yes, it is my theory, backed up by my analysis and all the documentation included in my report.
Thank you. Now I want to discuss briefly the term mining unit, and you mentioned it again today in your direct presentation. In your second report, you state that the term mining unit is used by the United States government in mining regulations and also in legal dictionaries, and that's in paragraph 26 of your second report. It's the last sentence there, the use of the term mining unit. And then you footnote to, you put a footnote 91. And looking at footnote 91, you're not citing to U.S. government mining regulations in support of that assertion, and nor are you citing for a definition of mining unit per se. Instead, you're citing to another definition, a term logical mining unit, correct?
That depends on which part of the definition you look at. Logical mining unit includes mining unit.
But it's a specific term. It's a specifically referenced term, logical mining unit, correct?
I saw the term mining unit used in the Peruvian law, so
That's not my question. My question
what
is,
is it
in
again?
the site that you are, the document you are citing in support of the concept of mining unit being in the U.S. government mining regulations and in legal dictionaries, you're not giving the definition of mining unit per se. You're giving the definition of logical mining unit, which is a different term, correct?
Conveys the same meaning, but the wording is slightly different. Yes, I agree.
Okay. And you also are citing to a reference to coal exploration and mining operations and referring again there to logical mining unit. So that's in the context of coal exploration, not copper exploration, correct?
The concept of mining unit applies to all mines of any type.
But that's not what you're citing to. You're citing to something specific to coal, correct?
In this instance, yes.
And I assume that you tried to find your best sources in supporting your statement. Is that a fair assumption?
I draft mining laws. Every mining
That's
law
not my
has
question.
this concept of
That's
integrated
not my
mining
question.
project.
That's not my
We
question.
use different terms.
That's not my question. I'll repeat my question. My question is, I said, I assume that you tried to find your best sources in supporting your statement. Is that correct?
Which statement?
The statement that you said in paragraph 26 of your second report that states, the use of the term mining unit to refer to a single integrated mining operation is consistent with how I have seen the term used in the United States mining regulations and legal dictionaries. I assume when you added that footnote, you were trying to put forward the best support you could find for that statement. Is that correct, or is that not correct?
Can you show me the
It's right there on the screen.
That's got the reference?
There's
There we
the
go.
sentence.
It's consistent with how I have seen the term used in.
That
Yes, it
wasn't
is
my
consistent.
question. My
Yes,
question,
it is
my question
consistent.
was not that. My question was, I assume you tried to find your best source in supporting your statement. Is that correct or not correct?
Supporting which statement?
That statement at the last sentence of paragraph 26 that's highlighted in yellow.
Yes, it does support that statement.
That wasn't my
It's the
question.
only. You know,
My question was that you tried to find your best sources in supporting that statement. Is that correct?
The best source I could find within the United States mining regulations is the one that's stated below.
Excellent.
Does that answer your question?
That does. Thank you.
Okay.
And let's look at a list of mining terms provided by the tax authority in the United States government and the Internal Revenue Service, which is behind tab 7. And this is Exhibit RE 235. And it's talking about, it's the IRS rulings and releases, and it's the revenue procedures. And it identifies there the purpose. The purpose of this revenue procedure is to index and set forth the definitions of certain mining terms that will be used by the Internal Revenue Service. Do you see that?
Yes.
And then if we look, then it says objective the definitions contained in the revenue procedure have been compiled from the regulations or from accepted industry definitions obtained from the sources listed in section C. And then it goes on to list an index of terms. And if you go see where mining unit might fall, which is between numbers 35 and 36, there is no listing of the term mining unit. Is that correct?
No, not really.
Well,
if you
is it
read
there?
the definition of the word mining,
Yes.
it has the meaning of an integrated mining operation, mining unit. If you go to the definition of mining, you'll see that.
There is no separate term mining unit, is there?
No, because they use the term mining to mean mining unit.
But my question is there a separate, unique term mining unit listed there?
There's no need to, because they have the term mining defined, which is an integrated mining unit.
Do you see the term mining unit listed there?
It's not specifically listed because they use a synonym,
Well,
mining.
You answered my question. You do not see it listed there.
I think if the question is about what is between mining and mining processes, it would be fair to show the expert the actual definitions of mining and mining processes.
I'm asking if he sees the mining unit referenced on the list, and he did answer my question eventually that it's not listed there, and I'm going to move on. And then it later on identifies references in point 6, and it lists 26 different references there. And number 19, these are the sources that they used in order to compile the list. And 19 on the list is the Dictionary of Mining, Mineral, and Related Terms published by the U.S. Bureau of Mines. Are you familiar with that, or did you consult that when you were trying to find a definition of mining unit?
No.
Indeed, and when you in the SMCB Peru hearing, you stated that in preparing your reports, you consulted glossaries in your reference library as well as those on the internet, and we can put that up on the screen. That was from day 7, pages 1935, starting with line 12. And I asked, in preparing your expert reports, did you look into any of the types of sources of dictionaries that are listed here in this index, which I was just showing you? The answer you said was, did I look at references from 1923 or 1924? Some of them are old. No, I did not. I do have some glossaries in my reference library. I looked there to see if anybody used that term, that specific term, mining unit. They did not. And then I asked, then I said, thank you. And then you continued and you said, I went to the internet, as everybody does, to take a look and to see. And I found 2 examples of people that were using similar language, but not the exact term mining unit. Do you stand by your testimony from the Cerro Verde unit, Cerro Verde hearing?
Yes.
Okay, thank you. Now, I want to turn to the issue of separate accounts. And you discussed in your reports the issue of separating costs between different mining processes and projects. And you talked about that today. Do you recall that?
Yes.
And I understand your position to be that it's difficult to separate costs. And you state that in paragraph 52 of your first expert report. Indeed, you state there, if we get to it. It's difficult. It's difficult to overstate the challenges associated with attributing shared mining assets and costs to one of 2 processing circuits in an integrated mining operation for the purposes of calculating a net asset or net profit tax. And you confirmed at the SMM Cerro Verde hearing that a mining company is capable of separating shared costs between projects. It was an answer to a question from President Blanche She asked, and this is in the transcript, day 7, starting on page 1937, line 12. She asked, am I correct in understanding that it can be done, but that one mining title owner might do it in one way? And then she goes on to say, and another might choose to do it on the basis of how many days worked, so it would be, she said, it would be arbitrary in terms of each would follow a different type of policy. And you answered yes. And she asked, so you could do it. It is just that there may be no consistency between the mines. And you answered exactly. And so you agree that it is possible to do. It may be difficult, but it's possible to do. You agree with that? You agree with your testimony from the Cerro Verde hearing, correct?
Yes, any method you'd come up would be completely arbitrary, and every taxpayer could come up with a different method, and that's why in my presentation, in my report, I say that a government that's going to come up with a unique and novel approach like Peru did here is going to need to provide detailed guidance through regulations, guidelines.
Thank you.
And then they could do it and not be subject to fines and penalties.
We'll get to that. But your testimony is today, as it was at the Cerro Verde hearing, which is that it is possible. You're saying it's difficult, it is possible, correct?
I'm not an accountant, but I assume they could come up with something.
Thank you. And let's look, in fact, at Mr. Aquino, who is a witness in this arbitration, in his first witness statement. And I believe we talked about this at the last hearing, but let's take a look at his chart, which is figure 17. And you see here that SMCV, in fact, keeps separate accounting for flotation and for leaching, correct? And it's just the top number, which would be mining. That is the shared cost between the plants. Is that correct?
Give me a second.
Sure.
So does this cover all the costs?
This is an example that he provides.
Administration, labor, all the, there's
Well,
just not enough information
it's not.
there.
Sorry. It is not necessarily defined what mining that combined one is on the top, but because this is an example he's giving of how they determine which core ore goes into which processing. But he's saying there is that common mining on top, and then it's divided. I'm just asking you if that you understand that as well. And then the flotation is one line, and the leaching is another line, so they're able to divide those separate costs. The one that might be common would be the top line. Is that your understanding as well?
They've come up with the unit cost for the leaching, the flotation, the mining, but it doesn't tell me anything about most of the shared costs. That would be things like labor, insurance,
it's not going
exploration.
Into it's not going into details, but it's stating it has that common. It's splitting up between floating and leaching the costs. Correct? There's a separate line item for each of those. Isn't that correct?
What it does is it tells you the unit cost for, like, say, a ton that's being floated, or the unit cost for a ton that's being leached, or a ton that's being mined, but it doesn't tell me what went into that. Does it include the shared costs of administration and marketing? It doesn't say.
Mr. Otto,
Yes.
it has a line item for flotation and it has a line item for leaching. Is that correct?
Yes, it does.
So it breaks that up. And your judgment, well, let's say in your judgment, those are difficult costs to split up between the concentrator plant and the leaching plant, but
some costs are not difficult.
Some costs are easy to divide. You've read, I assume, Mr. Robalski's reports, expert reports?
Yes.
And he talks about a method for separating shared costs in both of his reports. He discusses a methodology that was recommended in a technical advice memorandum issued by the U.S. Internal Revenue Service. And that methodology allocated shared costs on a basis of tons of ore mined. And if we could take a look at that, which is RE 49. What's the tab? Tab 9. And we'll put it up on the screen. So it's the Internal Revenue National Office Technical Advice Memorandum. And if you turn to page 14 there, and they are making a recommendation how to split up the costs that are shared. And it says, accordingly, in the paragraph, at the second full paragraph, and then starting with accordingly. Accordingly, down the second paragraph. Accordingly, yep, right there. Accordingly, absent separately tracking these costs, an allocation based on tonnage reasonably reflects the allocation a taxpayer would have made if the costs of each process were separately tracked. Therefore, an allocation of costs based on tonnage is a reasonable method. Do you see that?
Yes.
And according to Mr. Robalski, that methodology has been around for over 30 years. Is the information in this technical advice memorandum, is that new to you?
It's one of the most obscure documents I've ever seen. Yes, it's new to me. Any allocation that's going to be applied to a type of tax that takes both revenues and costs into account, it is based only on the value of the metal content, I think that's totally suspect.
The U.S., you're saying that the Internal Revenue Service is totally suspect in recommending this and having been applied for over 30 years? Is that your testimony?
I can't think of any country anywhere in the world except for the U.S. that would have something like this. It's so obscure.
And to confirm your earlier comment, you yourself don't have any experience preparing or advising mining companies on how to prepare tax filings, correct?
That is correct.
Now, I want to discuss a couple of statements that you made in your report, and also you made that today in your direct testimony. You stated that the Peruvian government did not provide SMCB with sufficient guidance to divide common assets, costs, and expenses between the leaching and flotation operations. And if we turn to paragraph 53 of your first report, you make that statement, and you also stated that in your PowerPoint presentation today on page 20, slide 20. You said Peru did not provide guidance on how shared costs should be allocated. You state here in paragraph 53, you point to Annex D, and if we could go to Annex D in your report, your first report, which is at the back of your first report. What is Annex D?
Annex D was a list of facts that were provided to me.
A list of facts provided to you. Okay. And if you turn to paragraph 17 of that annex, there. It states there, the government never provided SMCB with any guidance on how to apply both the stabilized and non-stabilized regimes to operations and assets within SMCB's single integrated mining unit. So that's not some conclusion you've reached on your own. It's something a fact that was given to you as assumed. Is that correct?
Yes.
And you have stated, and you state, I think just recently, that you would have assert that you would have expected Peru to have provided SMCB to provide shared costs, a way to divide the shared costs between leaching and concentrator projects. You would have expected the government to provide detailed guidelines on that, correct?
Yes, in line with the recommendation that, like you saw in my second report to the Ministry of Economy and Finance on a similar type of tax that would have required sharing of costs. I would have expected it.
You would have expected it. Is it your testimony that if a taxpayer does not get that kind of explicit guidance, that in your view it's sufficient for the taxpayer to do what they want, that they do not have to comply with the requirements of the law? Is that your testimony?
Can you break that question down a little bit?
Is it your testimony that if a taxpayer does not get the explicit guidance that in your view is sufficient, that the taxpayer can do what it wants?
No.
And you would agree, would you not, that for a large company like Freeport, if it needed any additional guidance on that particular point or any point concerning tax for that matter, it could hire tax advisors to help them understand their tax obligation under Peruvian law. Is that correct?
If you've got a EAU, it doesn't even come up.
Well,
there's no sharing of costs.
That's not my question, Mr. Otto. My question was very specific.
Okay.
You would agree, would you not, that for a large company like Freeport, if they needed additional guidance at any point, it could hire tax advisors to help them understand their tax obligations. Would you agree with that statement?
Yes, any company can hire a tax advisor.
And I assume that you're not advocating that a taxpayer should avoid its tax obligations simply because the regulations are allegedly not sufficient to provide guidance in the eyes of the taxpayer to undertake certain calculations, correct?
Correct.
I have no further questions.
Any questions by claimant in redirect?
Yeah, just a very brief redirect, Madam President. Could we please, with the assistance of opposing counsel, go back to tab 9, which is RE49 for the record, which was shown to Mr. Otto during the cross-examination? And Mr. Otto, you were shown this document during cross-examination. Do you recognize what this is? Is it?
I know there was some sort of tax memorandum that Hrabowski made reference to. I did glance through it. That was a couple of years ago.
And what jurisdiction is this from?
The United States, I'm told.
And did you, in your review of the Peruvian mining tax law and regulations, see anything that would authorize a Peruvian mining taxpayer to use cost allocation methods applicable in the United States?
No.
The next question I have is about Ramiro Aquino's first witness statement, which is figure 17. That was also shown to Mr. Otto. I'd be grateful if opposing counsel could also pull up that figure. Thank you. Mr. Otto, during your review of the Peruvian mining tax law and regulations, did you see anything that would permit a Peruvian taxpayer to use the cost allocation it uses for management purposes, for tax purposes?
No.
And in your experience advising on mining tax policy globally, what kind of advice do you typically give governments about having sufficient clarity in their tax laws and the risks of not doing so?
When I develop reports like I did for the Ministry of Economy and Finance, if they're going to be putting into place unique and novel approaches, I always recommend that they provide detailed guidance on how to proceed, how a taxpayer should proceed. And that would be the case with Cerro Verde, taking a look at new investments aren't covered by stability, so you'd have one tax system depending on whether it was invested this year, another tax system if it was this year, another tax system if it was this year. So you'd have to provide detailed guidance for something like that. Regulations, guidelines. You'd have to also provide training within the ministry on how to handle it.
And have you seen anything in the Peruvian tax law regulations that you reviewed that would constitute the kind of guidance that would be required to allow a taxpayer to know how to allocate shared costs in the way that Peru expected Cerro Verde to do?
No.
That's all we had for redirect. Thank you.
Any recross?
No recross.
Now, on us to ask questions, and with the permission of my co-arbitrators, I will start. Mr. Otto, I understand from paragraph 42 of your first expert report that with regard to the facts of this case here in this arbitration, you reviewed the factual summary in Annex D of your report. My question is, this summary of facts was provided by claimant's counsel to you. Did you also study underlying specific documents, for example, the 1998 Stability Agreement or the pre-feasibility study of 2002, or other official documents from Minim or Sunat preceding the investment in the concentrator?
I relied on the facts provided by counsel, but I also relied on, I read through many of the documents.
So you read through many of the documents?
Many of the documents.
This is not specified in your report, right?
That I read.
Which documents you consulted?
Well, you can see all the citation, the ones that I've cited, but I've read through the mining law, the regulations, things that were referred to by Rabowski. I read through, his citations. I read, I would make requests and they would send me documents because I would look for certain things that that I thought would be useful to the tribunal and useful for me to understand the situation too. So I don't know, I probably received 30, 40, 50 different documents, like the feasibility study, for example. They sent me some parts of it because I wanted to look at parts of it. So I did have more at my disposal than the documents or the fact statement that was sent to me.
And just to fully understand, so you had more at your disposal than the summary of the facts, and what you had in disposal and you relied on is included in your report in the footnotes.
What I relied on, I tried to, when I prepared my reports, I attempted to provide support for my various statements as drawn upon on references, and some of those were provided by counsel. Others were from my own collection or my own research.
Just as an example, for example, we discussed here the 2002 pre-feasibility study, and we noted that there were a lot of reductions in this document. And have you reviewed in preparation of your report the 2002 pre-feasibility study?
I received part of it, and I think I make reference to that in my my report. So the only part that I saw was the part that's referenced in my report. The feasibility study is usually, they're usually hundreds and hundreds of pages long. So I requested a certain part of it that I thought would be useful, the economic evaluation. And so you could see the exact pages I had access to if you're interested.
Thank you. Then the next question I would have relates to what you testified earlier. I understood you testifying, it is my theory that it is a worldwide presumption that stability agreements cover all investments within a mining unit. And you testified this on the basis of your 40 to 60 years experience in the industry in various countries. Have I understood your testimony correctly? This is your theory in which you truly believe, the theory of presumption.
Well, I think it's more than a theory. If we take a look at those countries, those are the countries that Peru competed with for investment in copper. In all but one of those countries, I prepared in-depth studies of their mining tax system. In some of those countries, I wrote their mining laws. I have in-depth experience in those countries. I know how stabilization worked in those countries. I helped design their stabilization. So it's more than just a theory. This is actual practice. This is my experience in Mongolia, my experience in Papua New Guinea. This is how it worked. It's not something based on some academic down in Australia who wrote a report for some academic journal.
And as you mentioned that you also published a lot, have you written on this theory, a presumption of scope of stability agreements outside of this arbitration and the SMM arbitration, outside of your reports? Can you refer me to any authority in which you have, independent from this arbitration, stipulated this notion?
The issue has never arisen anywhere else in the world. It's just not, it's a non-issue. The first time I heard about this was, this Cerro Verde situation. It just has never come up. It's not an issue we'd write about because it's not an issue anywhere else. And it wasn't in Peru. Prices went up. Senators started submitting all these bills. They're looking for a way to earn more money from the sector. And all of a sudden this new and novel approach appears, on the face, nobody's emulated it that I am aware of anywhere. It remains unique to Peru. And when I read the Peruvian mining law, and in my meetings with Peru, this issue of new investments aren't covered, it was never discussed. It was never on the table. And I worked with Mr. Polos, and Marita Chapuyas, and, the whole economic team twice, once in 2001 and then again, in 2011.
My next question relates to a similar statement in paragraph 45 of your expert report, where you speak of industry expectations that stability benefits apply to a mining unit. Can you refer me to any authority that defines such industry expectations as to the scope of stability agreements in Peru? If you said this was also the common understanding in Peru all the time, except in this case, can you refer us to any source which supports your opinion?
No, I couldn't point you to a single source.
Then another question in paragraph 45 of your expert report and also in today's presentation, you state, "Nothing in my review of the mining law and regulations in effect under the stability agreement leads me to conclude that Peru's stability regime applied to anything less than Cerro Verde entire mining unit." Now, in contrast, and this is what the case is about, in Peru and the Peruvian authorities and also the courts rely on the term exclusively in the mining law in order to say that a stability agreement relate to an investment project as defined in a feasibility study or somehow defined in a stability agreement or wherever. So what is your expert view on that?
Well, my view, when I read those key clauses, or Articles 82, 83, 85, you know the ones, of course, is that stability applied to concessions. And there were two types of concessions, the mining concession and the beneficiation concession. And it's an adhesion contract, which means that you read what's in the law, and then it's, the stability is formalized in this short little agreement. And what's in the law is what are the activities of a mining concession? What are the activities of a beneficiation concession? If you go to Articles 8 and 9 and 17 and 18 in the mining law and read those, it tells you if you have a mining concession or a beneficiation concession, what it authorizes you to do. And in 17 and 18, a beneficiation concession, if you hold that, you have the right to this whole string of different activities. And one of those is to develop processing plants. So they had these concessions. So if you read 17 and 18, they had the right to develop processing plants, plural. I mean, it's really clear there. So my view is the stability agreement is an adhesion contract. You have to read it in association with the mining law and with the mining regulations. And stability applies to the concessions that are set out in the stability agreement. And those are set out in the stability agreement. And, you know, Cerro Verde 1, 2, and 3, beneficiation concession. And then you read what activities are allowed. And you go to 7, 8, and 17, 18. It's all covered. There's no restriction on new investment.
This is also what I understood from your second report and also today's presentation, that you put a lot of emphasis on the fact that it is an adhesion contract that forms the basis of the stability agreement. Are you familiar with the particularities of how such stability agreements are then actually in practice concluded in Peru? And who applies for a contract, who fills it out, what is negotiated, what is not? Do you know about these particularities of the process?
Only what I can deduce from the law and regulations. I see no room for any negotiation when I read those, if that's your question.
Yeah, you just said it's a short little agreement, and what do you mean by that? And we heard earlier in this arbitration that even lawyers were involved in negotiating this agreement. So I just want to understand from you as an expert, how much do you know about the process of how such agreements come into place in Peru?
Well, when I read the form agreement, I saw nothing that was negotiable. The time period is set, the names of the concessions are set. I saw no terms there that you would actually negotiate over. If you'd like to draw my attention to one or another, I could tell you my view on that, but I saw nothing that was negotiable. Everything, all the various things that you might see negotiated in other countries are set out in the law. You get stabilization of this for this number of years. All those terms that might be negotiated in another country aren't negotiated in Peru. The adhesion contract, it's take it or leave it. You can't change something that's in the mining law. You can't change something that's in the regulations. You can't all of a sudden in the adhesion contract add some new obligation or new right. It's an adhesion contract. So you have to go back to the primary source, the mining law, the regulations. The adhesion contract is a way of formalizing the stability. But I saw nothing in there that you would negotiate.
Thank you.
Yes. Professor Roto, if I understood correctly, you advised Peru on mining issues and royalties at that time?
On 2 occasions.
Can you tell us a little bit about that advice, and particularly if it relates to any of the issues under discussion here?
Yes. Peru is interested in attracting investment It had come out of a period of really tough economic times, basically civil war, and they needed to bring in foreign investment to help rebuild the country. Their mines, which were mainly under state ownership, had failed, and they decided to privatize. So they undertook an effort to modernize their mining law, bring it up to date, to incorporate such features that would be useful to updating it. And part of what they wanted to do was to have a fiscal system that would provide a fair share but be attractive to foreign investors. So I was invited by the Ministry of Economy and Finance to come down, and I spent several weeks meeting with various stakeholders, industry, government, accountancy firms, whoever they wanted me to meet with, and the people that I requested. So I met with a lot of different people. I then went back and did a lot of economic modeling to take a look at how does their current system compare with the systems in other countries, and taking a look at different measures to take a look at the competitiveness of their system and to make recommendations tax type by tax type about whether they should keep their current system or make changes to it. And I made I think two or three recommendations that are pertinent here. One is that they impose a royalty, that there was room in order to still be competitive. They could get a little bit more money by putting into place a royalty, and I recommended a cap of around 3% on the royalty.
Could you put that in time? When are we?
This would have been, I think, 2001. 2001. I took a look at stabilization. I said, this is really important for the country. You should retain it. There was no question back then about new investments and versus old investments. It was all, you got the project, you got it stabilized. If you read the report, it does talk about stabilization, and they should keep it. They should put in place a royalty. There was also,
sorry, how would the royalties work under your advice?
Under my advice, I think it's been a while since I've read that report, but I believe I recommended putting into place a royalty not to exceed around 3%. What they ended up with was a royalty that didn't exceed 3%. It was a graduated 1, 2, 3 step royalty in line, not exceeding my cap.
What would happen with ongoing projects with stability clauses? Was that discussed at all?
Yes, it was discussed. It was discussed with the government. It was discussed with industry. And so when I met with industry, it's like, what do you guys think about a 3% royalty? And it was like, well, we've got stability agreements that won't apply. And if they try to make it apply, we're all going to sue. And so that was the view of industry. So if we've got a stability agreement, we're covered. And I think that was pretty uniform. I heard nobody on the industry side who didn't
And what was the position of the government, of Mr. Polo and the rest of government officials with the projects with stability? Was this issue of the feasibility study raised? Can you explain a little bit more in detail?
Well, I'll have to say that stability was not the main focus of what we were doing. So this was a very minor subject. The main discussion, and I wasn't really in the center of that discussion, was whether or not royalty was a tax or not. And so I sat in on discussions about that. And it, to me, it was obviously a tax, but there were lawyers and economists in the room were saying, oh, well, in Peru, royalty might not be a tax. It could be like an administrative fee. And then the question is okay, a stability apply to just taxes, or does it apply to administrative matters also? And so I don't think there was ever any sort of resolution other than me leaving knowing that if mining companies that had stability agreements were required to pay it, they were all going to sue. It wasn't really wasn't a focus of mine other than to advise the government, yeah, stability's good, you should keep it as you reform your system.
Okay, thank you. No further questions from my side.
I read with great interest your two reports, and I follow your intervention today. I think we are convinced that you have a great global experience in the mining industry, and your advice is very important for states in which you have been active. My question is, when a foreign investor decides to go into a country, has to make a risk assessment. And one part of the risk assessment is the legal situation. I saw that you were very critical to the situation in Peru. You were criticizing especially the adhesion contracts, but anyhow, that's what the foreign investor accepted coming to Peru. And we, as arbitrators, we have to apply the concrete legal framework and the contract itself. I mean, how could you advise us as a tribunal who have to take a decision about those questions we are facing, but within the legal framework and within the contract you are criticizing so much?
Oh, I think perhaps there's some misunderstanding. I think the approach they've taken in Peru with putting the main stabilized tax terms and so forth in the mining law is excellent. I think the idea of having an adhesion contract is excellent. I have recommended the same approach in other countries because it is such a good approach. It's unfortunate that this controversy has arisen. It's been extremely successful. If you take a look at how much investment Peru has attracted, and the fact that they still use stability agreements today, I think is indicative of the success they've had attracting investment to Peru. And tax stabilization, I think, has been an important part of it. It's not, the entirety of it, but, having a reasonable tax system stabilized so that a company can, when it does its feasibility study and determines, is it going to make profits or not, it knows, for that stability period that things aren't going to change. That's powerful. In their approach of using a combination of the mining law with formalization through an adhesion contract, I fully support and recommend it. I have no problem with that approach at all. Highly successful.
Thank you very much.
Any follow-up questions by the parties?
None for claimant. Just for the record, the report that Arbitrator Tawil was asking about is Claimant's Exhibit 19. That's the report that Mr. Otto provided to Peru in 2002, which is referenced in, I'm sorry.
Noted.
I'm sorry, it's 381. It's 381. Claimant's Exhibit 19 is Mr. Polo's presentation that references Mr. Otto's report. Sorry about that.
So it's CE 381.
Yes, Claimant's Exhibit 381.
Okay, thanks.
Any follow-up questions by the respondent?
No follow-up questions from respondent. Thank you, Madam President.
Thank you, Mr. Otto. This concludes your testimony. You are released as an expert in this proceeding. Thank you very much.
Thank you.
So shall we make a 15-minute break and then start with your expert?
That would be fine with respondent.
Good afternoon, Mr. Ralbowski. Welcome as expert for the respondent in this arbitration. I saw you today, so I think we do not need to introduce ourselves. So let us start right away. Can you please be so kind to read out the declaration under Article 35.3 of the arbitration rules?
Of course. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. And do you have your expert reports RER 4 and 9 in front of you and can confirm that they are yours and that they are correct?
Yes, ma'am, I have them here. I see my signature on my first report. I see the second report and my signature as well. And I am sure I have no changes, and I'm sure they are complete and as submitted.
And do you make a presentation?
Yes, ma'am.
Is it already available? Yes, for everyone, then please go ahead.
Thank you. Madam President, gentlemen arbitrators, thank you for allowing me to present my direct testimony in this manner. Like the two reports I've given, as well as this presentation, it is my goal to be efficient and effective and provide something useful for you. And you can see by the title of this presentation that I'm going to be quite focused on the 1998 Stability Agreement throughout my presentation. Let's talk a little bit about... Sure, thank you. I'm very conscious of my 30 minutes. Let's talk a little bit about me for a minute. Believe it or not, 50 years ago, come September, people started paying me to be an accountant. And I've built a career in accounting, law, and tax since then. And for 36 of those years, I have been a mining tax expert. I have an undergrad in accounting and a JD in law. And I've gained much of my experience when I joined PwC, then PW, in 1987. And I working on mining companies, international mining companies, and quickly became the U.S. mining tax leader about 6 years after I arrived, and then the U.S. mining leader cross-line of service. And then in 1998, I took over as the global mining leader for PwC until I retired in the year 2014. I've had the privilege of teaching both in PwC's America's School of Mines, and I was engaged after retiring. The 2014 is when I retired from PwC. I aged out at 60. And I've also had the privilege of teaching a law school class on global mining taxation at the University of Arizona Law School. I knew one of the leaders of the mining school there. She asked me to come to present a class. So I actually wrote a 3-credit-hour class and then presented it. And so I have a great deal of experience internationally talking about things, but I made my living as a tax practitioner, where my advice often ended up at the end of the day on a tax return where I had to pick up the pen and sign under penalties of perjury, just the same as the taxpayers do. And so what I have seen, the bulk of my approach has been from that angle in working for clients, although also advising governments. But I'm well aware of you need to know the law, you need to make decisions about how to treat things and not have the luxury of presumptions and undefined terms. Let's start at the beginning. The question here is the 1998 Stability Agreement, and the issue under that is the primary sulfide processed through the concentrator project that came online in the year 2007 included in the 1998 Stability Agreement? And my very clear answer to that is no. The 1998 Stability Agreement includes the leaching project only. So let's pause for just a moment and do a little mining 101 and talk about how quite different these two types of copper ore are. We have two types of ore, two processes, and at the end of it, two products. So we have the original ore included in the 1998 Stability Agreement, which was the oxide and the secondary sulfide ore that was removed from it was mined, went off to the leach pads, and then through SXEW became electro-on cathode, copper that is 99.99% pure. The later ore
The ore that came online in 2007, when the big concentrator came online and was excluded from the 98 stability agreement, was primary sulfide ore. It went through a concentrator. It was crushed and ground, went through a concentrator, and when they were done, they had concentrate. Concentrate is a fine black powder. Once it dries, 25 to 30% copper, a vastly different product. And SMCB did what many mining companies do. They shipped that off to somebody else to be smelted and refined and turned into useful copper. The 98 Stability Agreement was based on and specifically refers to the 96 feasibility study. The 1996 feasibility study detailed the expansion of SMCV's leaching operation of the oxide and the secondary sulfide. Remember, this is a couple of years after SMCV was bought from Minera Peru, and they'd been leaching, and in 96 they were continuing leaching and expanding it. The stability agreement that SMCV applied for, and their own label of the agreement was, quote, the leaching project of Cerro Verde, close quote. Neither the 96 feasibility study nor the 98 stability agreement included the primary sulfide or the concentrator. Again, it's very important to focus on the years we're talking about here. You might say, so why wasn't the primary sulfide and the concentrator included in that 98 stability agreement or in the feasibility study? It wasn't economic. Mining the sulfide and processing it through a concentrator in 1996 wasn't economic because for a good scientific operational reasons. It wasn't a political thing. There was inadequate power and water. Mills take a lot of power and water. Not only was there not enough, especially the power, it was unreliable at times in that part of Peru. Mr. Davenport, one of claimant's witnesses, testified that Phelps Dodge was one of the companies that bid on Minera Peru in 93, and they declined because the returns on the primary sulfide were unacceptably low to them in 1993 as they made their analysis. SMCV was offered to 50 companies. Cyprus was the only one that said yes. So we have on the record Phelps Dodge saying no thank you because we can't make money. We can't run this concentrator and mine the sulfide. Mr. Davenport continued, that was still their position at SMCV in the year 2000 when he got there. Further proof that the 98 Stability Agreement excluded the primary sulfide and the concentrator was Mr. Davenport saying in his report, they, SMCV, Phelps Dodge were worried that there was an obligation to build a concentrator. And because it was not economical, that was not an obligation that they wanted from the Peruvian government. He went on further to say that as they mined the oxide and the secondary sulfide, because that's what they were running, a leaching operation, when they encountered primary sulfide, they went around it, or if they had to mine through it, they mined it and they threw it away as waste. His word, waste. That's what this was in 1996 and 1998. Sulfide in the ground that can't be economically processed is not a worthwhile ore. Notice he also did not say when we had to mine through it, we stockpiled it. Stockpiling is what miners do when they encounter ore they believe is useful and they can process it, but not right now for one reason or another. So they put it aside, they preserve it to go back and get it and use it when it's appropriate. They did not stockpile the primary sulfide there at SMCV. Here we have what I think is the most persuasive reason as to why the primary sulfide and the concentrator are not included. This is a letter, it's Exhibit CE11. This is a letter from Cyprus, who was the majority shareholder of SMCV at that time. In September of 1996, which is the summer of when the original feasibility study for the leaching was submitted to peruse government authorities. This is a letter from Jeff Clevenger, who was the president of Cyprus, saying, pursuant to our share purchase agreement and our schedule of investments we are required to make, we are exercising our right to reduce that financial obligation because a mill is uneconomic. It is beyond our control, our being Cyprus and SMCV. It is beyond our control to build an economic mine. He mentioned the power and the water, but he also said this ore is unusually hard, and the technology to grind it is expensive, and separating the copper from the ore is especially difficult. Complex, he said, complex recovery. So at the very time that SMCV was applying for a stability agreement for the leaching plant, they wrote this letter exercising their right under the share purchase agreement to get out of a financial obligation. A most affirmative act, in my view. We've heard about this alleged presumption of inclusion with regard to the primary sulfide and the concentrator. No such presumption exists. Stability agreements define what project or activity or investment is included in the agreement by specifically describing what is included. Mr. Otto failed to prove that any such presumption existed, and I address his 7 country examples in my second report. Mr. Otto takes this presumption and says, and it applies to mining units, which we've seen he can't really define. And I'm not saying people don't use the term mining unit, but it does not have. It is not a term of art within the industry. If I say to a colleague, hey, I want to talk to you about the mining unit, he or she's going to say, okay, what do you mean? Now, I think, interestingly, you would need context to know what I meant. Interestingly, the term that he started using, mining unit, quite clearly in his first report, by the time he got to the second report, it was a single integrated mining operation. I think this is particularly interesting because an integrated miner is a term of art that's used in the mining industry, but it doesn't mean what Mr. Otto means. It says it means. It doesn't mean mining unit. An integrated miner is a copper miner that mines the ore, processes it, concentrates it, and when it's done, it has concentrate. It's the end of the mining process. An integrated miner also owns a smelter and a refinery, the so-called manufacturing that you need to turn concentrate into useful copper. SMCV is a non-integrated miner. It has a mine, it has a concentrator, SMCV today. It has a mine, it has a concentrator, but it doesn't have those further manufacturing facilities. So it is a non-integrated miner. No big deal. I believe one of the Phelps Dodge documents talked about the fact that more than half of copper miners are non-integrator. It's truly not a big deal within the industry. But integrated miner is a term of art that means nothing at all what Mr. Otto is suggesting. So let's talk about how different these two types of ore are. We've heard it talked about a little bit. Let's be clear. The oxide and the primary sulfide are identified while still in the ground. They have to be. When you come to a mine face, it's going to be blasted, it's going to be scooped, it's going to go into a haul truck, and whoever's driving that haul truck has to know where it's going. Is this sulfide? Am I headed to the concentrator? Is it oxide and I'm heading to the leach dump? So it's literally separated in everybody's mind before it actually comes out of the earth. And once it comes out of the earth, the oxide goes that way and the sulfide goes that way, and they never meet again in Cerro Verde's case. And again, producing completely different products. Cathode through the leaching, concentrate for the sulfide. I talked about this in my first report, and then in my second report I thought, I'm not sure the tribunal is going to understand the value difference of the original oxide in the 96 feasibility study and 98 stability agreement and what ultimately happened with the sulfide. So I have here on slide 12 some excerpts from two, what did I call it, figures that I had in my second report. If you look at the red line, the copper colored line in 1996, and by the way, I used saleable copper because that was a term used in both the 96 and the 2004 feasibility studies. And that's a common term. This is all the copper we think we're going to be able to produce based on what we know when the mine is done. So in 96, at 90 cents, which was the price of copper, 90 cents per pound, the oxide cathode was worth $1.7 billion. In 2004, when the feasibility study was done for the new huge concentrator, the copper price was still 90 cents, and that sulfide that was going to be turned into concentrate was worth $10.7 billion. That sulfide is about 6.5 times bigger than the original oxide. It takes time to build a concentrator. 3 years later, the concentrator is built, it gets approved, it goes online in 2007, and the price of copper is $3.28 a pound. That value, that saleable copper value, is in the green there at the bottom, $42 billion. About 27 times larger than the original value of the saleable copper of the oxide back in 1996. 2007 is also a really interesting year because this is when the taxpayer, SMCV, had to put all this on a tax return. That's what they were looking at, those kinds of prices, that magnitude, when they chose to take the position, yeah, we don't need a new stability agreement, we're included. We're going to file our return this way. I want to step out for just a moment. We had discussions yesterday about Sunat and in the years before 2007, and the discussions of, gee, didn't you hear that SMCV thought the concentrator was in the 96 feasibility study and the 98 stability agreement? You kind of, why didn't you reach out? We heard that from people in the room. Taxpayers communicate with tax authorities by filing timely, complete tax returns and signing under penalties of perjury. And tax authorities respond by accepting it as filed, a desk review, or we know we're going to go audit, which would always happen with a big company like this. Think about this for a moment in your setting, and you're in the middle of an arbitration, you're gathering facts, and somebody says, can I just get clarity on this really one important fact? You can't. You need that tax return to know exactly what position that taxpayer is making. And if I may, think of it also in terms of your own home country, whatever SUNAT is to you, IRS to me, whatever it is to you, I don't think any of us really want your version of SUNAT reaching out and saying, hey, I heard you were thinking of doing something, and let me tell you how I think that might turn out. Nobody wants that as a taxpayer, and the governments don't want that. File a return, and I'll judge it from there. Switching gears for just a little bit, we see that there was a pilot concentrator. Concentrator Zero, Mr. Aquino called it. That was around for many years and was, interestingly to me, dismantled in 1997. And I say interestingly, and I don't have a piece of paper to support this, but I do find it very interesting that during the period of when they applied for the stability agreement and sent the letter to Empresa Minera Peru and said, we can't build a concentrator, wait, we've got a concentrator out back. And I think that's when it got dismantled. But I have no proof of that. That's just my theory. Very coincidental. Claimant has alleged, well, we were doing concentrate all along. this concentrator zero that started out as, I think, 100 pounds a day or maybe 1,000 metric tons a day, and at its peak was 3,000 metric tons a day, would have taken, in Mr. Aquino's estimate, 3,600 years, working 24/7, 365 days a year to process the 4 billion metric tons of primary sulfide reserves. Mr. Davenport talked about it. He called it proof of concept, and that makes perfect sense. It's sulfide, and you say, oh, that's got to go through a concentrator. That's all true, but that's all really general. People do tend to try to figure out how might this work exactly? Ladies and gentlemen, I submit that this pilot concentrator that got dismantled in 1997 is nothing like the 108,000 metric ton per day concentrator ultimately built by Cerro Verde, and confers nothing to it in terms of the stability agreement. And we had a lot of talk just a moment ago about separating revenues and costs. So I'm going to show you that Cerro Verde actually does both. I'm going to show you in their financial statements where they separate the revenues, and then we're going to come back to Mr. Aquino's typical separation of costs. So Cerro Verde's 2010 financial statements, it's footnote 24. You see highlighted there production in 1,000 of recoverable tons. The comparative years, that's what financial statements require. In 2010, the cathodes, remember leaching produces cathodes. The cathodes, 183,000 recoverable tons in 2010. The concentrates, 484,000 metric tons. And you see below there, the LME, the London Metal Exchange price for copper for that year. You do the math and you have your revenues. But costs, I think we can agree the revenues are really easy. They tell people about it in their audited financial statements. Costs are also really easy to be separated. And as we're about to see, Cerro Verde did it itself, does it in running its business as it should. So the example Mr. Aquino gave is they had some secondary sulfide that legitimately could go through leaching and get a recovery, or legitimately could go through the concentrator and become concentrate. So the question became, okay, science-wise, this works. I can go either way. I want to know which one makes more money. And that's the exact question they should be asking. So he shows us in this figure 17 that he says is a hypothetical block calculation, but he says it's a typical calculation, and I seriously doubt Mr. Aquino would have given us numbers that were not representative. And he shows us the data. The blue boxes, those are the shared mining costs. The unit cost per ton of $1.20. 17% of the total of all the costs here. The flotation, very expensive, $4.50 per metric ton. The leaching, ROM, that means run of mine. The leaching, $1.35 per metric ton. So they took whatever this block was, and they ran the numbers, and they said, okay, if we run this through, what will the financial numbers look like if we float it? And that's down in the green section, and with the flotation, wow, revenue $91,000. That's good. As compared to the leaching, which is $71,000. Then you go to the next column on the right in the costs. The marginal costs on the concentrator twice as high, $57,000 versus $25,500. And so you get over to the net number, and it's a pretty easy decision. We're going to run that through leaching because our net will be $45,000 instead of $34,000. In the prose that went along with this, Mr. Aquino talks about we didn't even run the mining through these calculations because we had to do it either way. And all the other costs Mr. Otto was alluding to, where's HR, where are the tax nerds? Where are those other costs? He talks about those other costs and he said, oh, we allocated all those over to the flotation because that was the bigger value. He didn't say, well, we simply can't run these calculations because we don't know how to separate these numbers. They did it. They did a perfectly logical thing with respect to both. This is just math, and I'm about to show you a little bit more about that. So again, Mr. Otto says, not enough guidance. In quotes, it doesn't meet his expectations of, quote, reasonable detailed guidance. No one is allowed to ignore the law simply because it doesn't meet their expectations. As a tax practitioner, if a client wanted to do something that I didn't approve of, I wouldn't sign the return. And my own people, we never said, are you sure we have to follow this? But it would be taxpayers who would sometimes get pretty angry at me. But they also knew that I signed that return too. And if I wasn't going to sign it, they realized they shouldn't sign it. So let's talk about the, we'll make one other point. If they didn't know how to do it, and I believe this was really well known within the global mining industry, they should have gone and gotten help from a mining tax or an accounting methods and periods expert. That's all we're talking about here is accounting methods and periods, which is a branch of accounting in preparing your tax return. And this is a really basic calculation. So let's talk about the tech advice, the TAM, that I cited in my reports. And I discussed it in terms of the TAM so that if people wanted to go back and look at it, they could understand better. These facts are very close to what we have here with a couple of interesting twists. So we'll start with an open pit mine that has both primary sulfide and oxide, exactly what we have at Cerro Verde. Twist number one, in these cases, they were mining for sulfide first. They were there for the sulfide, and they were putting the oxide aside because they didn't know how to effectively process it. As technology got a little bit better and mining engineers did what they are supposed to do, they came to realize, well, we really can leach this and make money from it. So they started doing that. But there were mining companies that said, but I'm going to leave all those shared costs over at the sulfide. And the reason they wanted to do that, when I mine oxide for leach, it goes on a leach pad and gets sprinkled with that weak acidic solution for 270 days. And then that solution at the bottom, the PLS, the leachate, pregnant solution, gets captured and goes off to the SX plant and the EW plant to get caught in or turned into cathode. And then they do it again. You rinse the benches more than once. You let them rest and you rinse them again. So any costs that get allocated over to the leaching, they get hung up in inventory for quite a while. What taxpayers want is, how can I get my expenses through P&L as quickly as possible? When it goes to the concentrator, concentrates fast in relation. Weeks, months, and then you sell it, it's gone. And so the more costs you allocate over there, the more expenses you can get in your taxable income calculation and reduce your taxable income. When you're doing a tax return, you want your expenses to run through as quickly as possible to minimize your taxable income to pay the lowest amount of tax. That's what the controversy was in these revenue rulings. The late 80s, the IRS, Congress passed a rule that said, taxpayers, you have to be much more particular about your costs of inventory and things you build. You need to separate these costs in this situation. And so taxpayers did it. Some taxpayers, so that we're talking late 80s, 1990, my clients. Some clients took the approach, I'm going to wait till the IRS comes in and makes me. A lot of other clients said, I think we would rather develop our numbers and then go apply for a change in accounting method. And so that's what they did. So these TAMs that came out 20 years later-ish, that detail all this, that was a taxpayer that didn't volunteer to change. They waited for the IRS, and they fought about it. And the IRS agent said, okay, we're going to send it up for tech advice. And there were two parallel things. Is that my 5 minutes? 2 minutes? Oh my gosh. Those calculations can be done. You see, same thing in my report, shared costs, just allocate it based on tons moved Peru provides for this. They do provide guidance. It's in Article 2 of the regulations, because the other common way to do this is allocate it based on the relative revenue that goes around. This slide 23 talks about all the commentators that talk about the principles explained in that tech advice. This was a very well-known thing. The expansion of the beneficiation concession to include the big new concentrator did not confer stability on it. Mr. Otto thinks this is an economic debate. I do not. I think this is about the 1998 stability agreement and 96 feasibility study. Some things I had in my first report he didn't address. Let's come to the conclusions. Let's go to the second page. Look at the bottom. SMC itself separates the revenues and costs between the leaching project and the concentrator project. They do it. That's how they run their business. You can absolutely separate these costs by project. They want to float it back to 1998 because the royalty got enacted. They're trying to, in 96 to 98, they told Empresa Minera Peru, we can't build this thing. We're afraid of the obligation. And now they want to go back because, well, the race changed. I mean, who wouldn't want to go back to when prices were cheaper? The stability agreement from 98 cannot apply to the 2007 concentrator. Stability agreements are not hold my place situations. You can't have a company come in and go, here's $50 million, not paid as a fee or a royalty to the government. I'm going to go spend $50 million for my own company, and I want you to stabilize everything I do for 15 years, and I'm going to kick some rocks. See what I can figure out in 15 years, and
Madam President,
maybe I'll find
excuse
something.
me, I really hate to interrupt. It's just that the expert has gone over considerably his time, and we don't have a lot of time left for today.
Marisa, how much overrun does he have?
45 seconds.
Wow.
45 seconds, so if you can come to the end of your presentation, please.
Yes, ma'am. If you look at that last bullet, if the mining companies weren't required to act according to their feasibility studies and do what they were supposed to do, this land would just sit. This would not help Peru. Peru wants to give you a stability agreement because you're going to go do something with it and create jobs and buy things from Peruvians and sell things to Peruvians, not just tie the land up for 15 years or whatever the length of the stability agreement is. Thank you. Whoever gave me 45 seconds, thank you. Maybe I guess that was you. Thank you.
Thank you very much. Does the claimant want to start with a cross-examination? We have, I think, 15 minutes left today.
Yes, please. Thank you, Madam President. Good evening, Mr. Elbowski.
Good evening.
Good to see you again. Thanks for joining us. My name is Nawi Kabila. I'm part of the Freeport Council team. I'll ask you a few questions about your testimony. So just first, a bit about your qualifications. You are a certified public accountant, correct?
I am licensed in both the District of Columbia and Arizona.
And you've spent your career working in accounting firms?
No, my very early days, I was an assistant controller for Sears. After law school, I practiced law for a bit, and then in 1979, I joined Arthur Andersen and went into big company tax accounting. Yes.
Right. So, and during the course of that career, you signed thousands of tax returns, right?
I did.
And your clients were largely made up of private sector companies?
No, I advised private companies. I advised, especially as the global mining tax leader, I advised governments. I was sought out for commentary about tax policy. I worked for mining industry associations. It was a wide spectrum involving the mining industry.
Were you ever retained by a government to draft a mining law or a regulation?
I was engaged usually with members of a local office if I was working on something international for tax policy. I was
by
hired
a government to draft a mining law or a regulation?
Well, I was hired as a, thank you, a lobbyist on behalf of the National Mining Association to go work with the committees that were working on a proposed change to U.S. mining law. So pick up a pen and draft, no. Talk to them about what I believe is a
Are there any mining stability agreements in the United States?
You know, that question was asked in February, and I said no. And mining stability per se, maybe not so much, but we do have stability agreements in the U.S. more at the local and state level, and there are ways that taxpayers. I would submit that a taxpayer approaching the IRS to change its accounting methods is a bit of a stability agreement. I want to do something. I'm coming and asking for your permission to do this.
I'm sorry, Mr. Robofsky. Are there mining stability agreements in the United States of America?
There might be at the state level. I do not know for certain.
When you would work in foreign jurisdictions, did you ever file the tax returns in those jurisdictions?
I did not. The local office would have done that.
Right, the local office. So when you were advising companies in foreign jurisdictions like Peru, you'd have the support of a local office with a local team of local accountants and locally qualified attorneys, right?
I did, but many of the issues that were involved required both sides, say the home country as well as the local country, to look at the laws and understand them.
Right,
So,
but your
example,
reports don't
qualified-
have both sides, right? Because you didn't have a local team of Peruvians helping you prepare your reports, did you?
I'm sorry, I was talking over you. Can you say that? Ask me that again, please.
Yeah, no, I think that you agreed that you would have both sides, including the local
Absolutely.
support when you were advising companies in foreign jurisdictions on tax matters. Did you have local support from Peru helping you prepare your reports in this case?
I did not.
Okay. Now, in his first report, Mr. Otto described mining stabilization in numerous jurisdictions: Argentina, Chile, DRC, Indonesia, Mongolia, Papua New Guinea, and Zambia, right?
I believe that's correct. That sounds like the countries, yes.
And you're aware that Mr. Otto has extensive experience with mining stabilization in those jurisdictions, including drafting some of those laws?
So he says.
Okay. And you didn't respond to Mr. Otto's analysis of mining stabilizations in those jurisdictions in your first report, did you?
I did
You
not.
waited until your second report so that he could not respond to you in his second report.
I wish I was that clever. I didn't respond to them because we were dealing with a stability agreement in the country of Peru. So I focused.
So why did you respond to it in your second report then?
Because he was still there, and he was claiming, well, Robofsky must agree.
But you agree is that the effect is that you deprived Mr. Otto of the ability to respond in
I
his
didn't
second
deprive
report.
Mr. Otto of anything. Oh, sorry.
Sorry, I got it.
Sorry.
Yeah, I'm sorry, I'm going too fast. I'll slow down. So, Mr. Robofsky, is it fair to say that the main subject of your testimony, or at least one of the principal subjects of your testimony in this case, is your opinion that Cerro Verde's 1998 stability agreement didn't apply to the concentrator?
That is correct.
And the scope of a Peruvian law adhesion contract is a question of Peruvian law, right?
The scope of this Peruvian adhesion contract is a matter of the facts. The adhesion element of the contract defines how the government operates.
I'm sorry,
The scope.
If you could just answer my question, the scope of this contract is a question of Peruvian law, right?
I disagree.
Okay, so I think you agreed at the SMM hearing in February that a question of Peruvian law has to go to experts on Peruvian law.
Sir, that's a different question. That question is asking about Peruvian law and Peruvian law experts. You asked me about the scope of a Peruvian stability agreement, and I'm responding to you that the scope is a question of fact.
Okay, so your testimony is that
Yes, sir.
that the interpretation of a Peruvian law contract doesn't hinge on the application of Peruvian law.
That's not at all what I said, and I believe you know that.
Okay, well, does it?
Does it what?
Does the interpretation of a Peruvian law contract hinge on an application of Peruvian law?
Yes.
Okay. And Peruvian law is for Peruvian experts, right?
Yes, but as a tax expert, I
think
face
you've answered my
many
question.
things
We can move on.
across all sorts of agreements, contracts, and I've done this for many, many years.
But in your reports, you didn't cite a single article you ever published on fiscal stabilization, did you?
I did not. Well, actually, that's I didn't cite any. In my law school class, I talk about it, and I'm sure I have talked about it in speeches that I have given.
But you're not a qualified lawyer in Peru, are you?
I am not.
And you've never given expert testimony on Peruvian mining law in another legal proceeding, have you?
That is correct.
And I know you obtained a JD from Albany in 1978, but you're not qualified to practice in any jurisdiction, are you?
I chose to retire from the practice of law because I was working for an accounting firm.
Right.
But I still use all the skills that I learned while at law school and to this day.
Are you qualified in any jurisdiction?
As
a lawyer?
I am not.
And after you graduated from Albany Law School, you couldn't find a job as a lawyer in New York, right?
No, that's not true. I worked for a small company as part of their corporate counsel.
Was that a mining company?
It was not.
Okay. And so your experience practicing law is limited to working in the corporate counsel office of a non-mining company almost 30 years ago?
My experience in law is all the skills that I learned while in law school and while I clerked in law school and while I interned at the New York State Assembly, and taking all those skills and working in large accounting firms where, for example, at Arthur Andersen here in DC down at 16th and K, over half of the people had LLMs. We were in the books constantly. People gave me their time on LexisNexis because I was so good in the library. So did I charge people using a legal license? No. Was I using all of the skills of a lawyer? Absolutely. And I continue to do that today. And I teach a class in the University of Arizona Law School.
But do you have any experience negotiating stability agreements in Peru?
I do not have negotiating experience negotiating stability agreements in Peru. I have a great deal of experience negotiating with tax authorities at the state level. I told you I've talked with Senate staff, House staff, state staff.
Okay, that's going far beyond the scope of my question. Just to sum up here, you're not qualified to practice law in any jurisdiction. You're not qualified in Peru, and you've never negotiated a stability agreement in Peru, but you're before this tribunal giving expert opinions on the negotiation of a Peruvian law adhesion contract.
I'm here giving advice as a international tax expert on how to interpret a Peruvian law, as I have been interpreting laws and regulations and cases for 36 years.
Right, I think we established that the Peruvian law is for the Peruvian experts, so let's move on. Do you have a computer, Mr. Albofsky?
I do.
Mac or Windows?
One of each.
One of each, nice. So when Apple or Microsoft updates its operating system on your computer and you get the little pop-up to agree to the terms and conditions, you click that pop-up, right?
I do.
You don't negotiate that contract with Apple or Microsoft for the use of the operating system, do you?
I can choose not to accept it.
Yeah, but if you do accept it, you don't negotiate with Apple or Microsoft, do you?
I do not.
Right, because it's an adhesion contract, right?
It's more they have you over a barrel, and we all do it.
Now, are you aware that stability agreements in Peru
sir, it's not really a contract. There's no offer and acceptance there. They're asking me if I accept their terms to continue using their product. There's no offer and acceptance as there is in this stability agreement.
So you don't agree that that's an adhesion contract?
I don't think it is.
Okay, so you've changed on that. Okay.
I did.
Okay. Well, you are aware that stability agreements in Peru are adhesion contracts, right?
I am.
But you testify that the scope of those stability agreements are negotiated in Peru, right?
I did.
And so that means, as an American accountant, you disagree with claimants' Peruvian law experts, Dr. Boulard and Ms. Vega, that the scope of stability agreements are not negotiated in Peru, right?
If that's what they said, I'm not familiar with that.
And you disagree with the testimony of Marita Chapuis, the former Peruvian Director General of Mining, who was responsible for regulating mining stability agreements in Peru, that the scope of stability agreements are not negotiated in Peru, right?
Could you show me that, please?
Well, I'll show you something even better. Why don't we show you the testimony of Peru's own Peruvian law expert, Professor Eguiguren, that said, if the mining law says that the scope of the stability guarantees is X, the parties could not then negotiate that the scope of the stability benefits be something different. And that is Claimant's Exhibit 1140, Day 8 of the Sumitomo hearing transcript for the record. Do you disagree with the expert opinion of Peru's own Peruvian law expert?
Let me read it. Let me read it. The mining law does not say, Peru's mining law does not say the scope of the stability agreement is X.
So is it that you think that the parties negotiate the scope, or that they don't negotiate the scope? I'm sorry, I don't understand.
They negotiate the scope. It begins with the mining company, A, choosing whether they want to be under a stability agreement or not, yes or no, and they may not be, and then they go apply for it, and through the feasibility study, they tell the government, here's what I would like to include in the stability agreement for which I'm negotiating.
Right, so then how does that not mean that you disagree with Mr. Eguiguren, who said the parties could not then negotiate that the scope of stability be something different?
I'm sorry, I'm objecting because he's mischaracterizing Dr. Eguiguren's testimony. Dr. Eguiguren's testimony says there is the scope, is what he's talking about, the contract of adhesions concerning the stability guarantees. That's a very different thing than what he just characterized, which was stability. And so it's a mischaracterization of the testimony of Dr. Eguiguren. And it's an inappropriate question to mislead this particular expert with a misquote of what Dr. Eguiguren testified to.
I think that it's very clear that Mr. Eguiguren is discussing the scope of the stability agreement, because
he is not. It says stability guarantees. You're misinterpreting that. That is absolutely incorrect.
If I can finish, because it refers expressly to the scope being X and the parties negotiating something different.
The phrase there is stability guarantees. That's a different thing than talking about the scope of stability generally, and it says the scope of the stability benefits. There he's talking about stability guarantees. It's very, very specific to the guarantees that are provided under law. That's what he's talking about.
This is what we read. I read stability guarantees and stability benefits, but maybe it's then a question we should ask to the expert who has made this statement, and
yes,
continue
he will.
with another line of question.
Yeah, of course, Madam President. So if I understand correctly, Mr. Ralbowski, it's that the parties can negotiate for the scope to be as large or small as they like. Is that correct?
There are still limits as to certain amounts that they have to commit to, but it begins with the taxpayer choosing what to put in the feasibility study, and just exactly what we have here, that Cerro Verde has a feasibility study for the oxide and the leaching, and very specifically left the concentrator out and asked to be let out of a contract. So in my mind, that is a negotiation. They chose what they wanted to see the stability agreement to cover.
Okay, so so what provision of the mining law governs the submission and the approval of the feasibility study that you say is part of this negotiation?
I'm sorry, ask me that again.
Yeah, it seems like you said that the negotiation starts with the feasibility study. What provision of the mining law governs the submission and approval of the feasibility study?
I don't recall the exact provision, but you get a stability agreement by applying for it. You start it by applying.
And so you don't know what provision of the mining law governs the commencement of this so-called negotiation. Do you know how long the parties have to conclude this so-called negotiation?
Again, the negotiation part is what the mining company decides before they submit their application.
So the negotiation happens only internally with the mining company, not with a counterparty?
Well, it's a contract. It starts with the mining company asks for stability for a certain thing, and then Minam reacts to that.
The negotiation part is what the mining company decides before they submit their application. That's your definition of a negotiation?
Not what I said.
That's exactly what it says.
The negotiation part is both the offer and then the acceptance.
Okay, all right, Mr. Rabowski, I think we disagree about the what negotiation means, but I think we also agree that you've never negotiated a stability agreement in Peru.
We do agree on that.
And you've never participated in a stability agreement application in Peru.
I have not.
Okay, now you've said that the government negotiates a narrow scope of stability agreements because the government would never give up more than it has to, right?
I'm sorry, where did I say that?
That is paragraph 37 of your second report. Countries do not offer more incentives than what is necessary to encourage investments, including and especially in the mining sector.
You'll pull that up, please.
Just a moment.
Council, just for further planning, how much more time do you need today to finish this line of questioning?
I think I could probably finish the entire cross-examination in about 10 minutes.
Would this be okay for the court reporters? I mean, we also have questions. I don't know whether you have any questions. So
I won't know until he's complete with his cross.
So, okay.
Okay, I'll do my best to wrap it up. If not, I'm hopefully we can continue tomorrow. Did you get an opportunity to review that paragraph from your report, Mr. Rabowski?
I do see it. Can you scroll up just a little bit? No, I can read the print, but can you scroll up just a little bit, please? So, in this section of my report, I'm talking about stability agreements in general, and that countries in general that choose to offer stability agreements, they need to figure out, what are we giving up here and what are we going to get for it? I've told clients and students throughout the years, mining companies do their best to represent their shareholders and other stakeholders. Countries do their best to represent their citizens. And that's as it should be. Each one comes to the table representing their party. And there's another quote in there, I think, from a study I was reading. Mining countries only want to give up what they need to get the investors to come in. Why would they give up more? They shouldn't. They're representing their citizens. So that's the context in which I wrote that, when I was talking about stability agreements in general.
Right, and so the mining company also equally would not give up more than it has to, correct?
It really depends. So
the government will give up more than it has to.
He's not finished giving his answer. Let him finish his answer, please.
There are many ramifications to entering into a stability agreement. And if I may, and I'll tell you the Reader's Digest version of this. Years ago, the price of gold went from $800 to $1,100, and in the U.S., tax assessors at counties said, your assessment's going up. We have to charge you more tax. And that happened. And when the cycle came around to the other side and prices dropped, mining companies went back to the assessors and said, hey, our mines are worth less. Lower our assessments and we'll pay less. The counties had to do that. Then the counties realized they didn't have enough money to run their schools and other things, so they either had to cut services or they had to raise everybody's rate. So I had clients who chose not to take advantage of a benefit they knew they would win on because they didn't want the bad press of being the reason the county had a shortfall. And when services were cut, the services at the schools, et cetera, that's where their kids went to school. So yes, there are instances where mining companies don't take advantage of everything they can because of the broader picture of what's going on in their world.
Well, you're talking about the U.S. again, but all of those considerations would equally apply to the government in this so-called negotiation, right?
I'm sorry, I don't understand your question.
Well, it seems that you're acknowledging that stabilization doesn't necessarily mean that you lock in lower tax rates. And so the company may not negotiate the broadest stability according to you because it doesn't necessarily lock in lower tax rates. Doesn't that equally apply from the government's perspective?
I'm sorry, I don't know what that means. Equally apply how?
I'm just trying to understand what you're saying, Mr. Rabowski. Are you saying that the company will not negotiate the broadest scope of stability possible because it may imply locking in a tax rate that's higher than what the tax rate will be, for example, next year?
That might be. There are you might have a taxpayer that says, I really think this country is going to respond in a couple of years by lowering their rates. I think that's how they will attract investment. So I'm not, even though they offer stability agreements right now, I'm not going to go seek that because I'll be locked at this rate, and when it drops to here, I'm stuck. I would rather take my chances and not do it. So people have to decide what they think is going to happen to decide whether they want to go apply.
Right, and so the government would also need to know what the tax rate is going to be in the future in order to be able to project what they're giving up by entering into stability, right?
Obviously, nobody knows the future, but people make assumptions and projections based on where they think things are going, not the least of which is what's the value of the metal going to be here. So yes, they have to make some assumptions and projections and make decisions today and hope that they're calculating right how the future is going to turn out.
Right, and so you agree that nobody knows the future, so any projections about what the country is giving up would be based on assumptions.
It is going to be based on assumptions, but it's based on mine plans, the feasibility study, in this case, that people turn in. It's not just a spin of the wheel. You've got something to go by.
But you've never done this negotiation before, though.
We worked, I had a project with my staff working for the state of Alaska, where we ran projections. We were hired by Alaska to help them project what they thought the Alaska mining tax law.
You might have misunderstood my question. Have you ever done this in negotiation in the context of a stability agreement?
I thought I was answering. You're right. I've not negotiated that particular agreement, but I've worked with projections.
Have you ever negotiated any stability agreement?
Sorry, could you let him finish his answer to
Well,
your
the
question?
answer is not responsive to the question.
Well, he was giving a more fulsome answer. If you let him respond to the full answer, give his full answer to your question.
Please.
We were helping the state of Alaska project what revenues were likely to look like based on the mining activity they had going on at the state and trying to determine how they should or should not modify their taxes going forward.
Right, but Mr. Rabowski, you've never negotiated a stability agreement.
Okay.
No, that's a question.
I said, okay, yes.
Yes, okay,
That's
thank
an
you for
answer.
confirming. And Alaska doesn't have stability agreements in the mining sector.
No, but they have laws.
Great. Okay, Mr. Rabowski, so it's crystal clear to you, an American accountant, that the 1998 stability agreement didn't apply to the concentrator, right?
Repeat your question.
It's crystal clear to you that the 1998 stability agreement didn't apply to the concentrator, right?
Yes.
Okay. And you were able to determine that by doing what? Reviewing the stability agreement and the record in this case?
Yes.
But you have already admitted that you don't have any experience interpreting Peruvian law stability agreements, do you?
No, I didn't admit that. As a tax professional, experience for, guess what, 36 years in mining and I think 42 years in big company tax, I am very experienced in interpreting laws from around the world.
Peruvian law stability agreements.
Well, in this case, I can read it, and if it's a Peruvian
Have you
law
ever
stability-
interpreted a Peruvian law stability agreement?
I did it to write these reports, yes.
Right, before your testimony in this case.
I did not have the opportunity to do that, no.
Okay, so if you seem to be relying so much on your accounting experience, is it, please explain it to me, is it that like in the course of conducting an audit, you would notice, hey, this stability agreement doesn't apply the way the company thinks it does, and then you would tell them that?
That's not at all what I've been saying. I am a tax accountant. When I was a partner, I had a pen, but I never signed financials. As a tax accountant, I use my skills, which I learned through law school and the practice of law and my law clerking and all those other things, as well as the work as a younger staff at Anderson, to research, write, represent clients at IRS and state exams, advise governments, go to appellate conferee meetings and represent my clients. Those are all skills as a lawyer. I couldn't charge people as a lawyer because I wasn't licensed as a lawyer because I worked for a CPA firm.
I'm sorry, we're really running out of time, Mr. Albowski. That is not my question at all. I'm just trying to understand in what, how it would arise through your accounting practice that you would interpret a foreign stability agreement. How does that happen? Explain it to me.
I am explaining it to you. I have a tax accounting practice. I read and interpret and influence tax laws all the time.
Okay, so if, for example, if it was a Peruvian stability agreement, you would consult with the PwC team in Peru about the scope of that stability agreement, right?
No, I feel very competent and confident in what I've read and interpreted and wrote.
So if you were working in Peru, you would, for PwC, you would ignore the local advice of the Peruvian lawyers?
I didn't say that at all.
So you're now contradicting yourself. I'm sorry. If you were working on behalf of a Peruvian company with a Peruvian law stability agreement, would you or would you not rely on the Peruvian team with Peruvian qualified lawyers?
I am not, contradicting myself. I'm trying to explain to you that I believe I have the skills to interpret tax laws as I have done here, and that's the work I have done. When I was, you're concerned about time. Sorry.
Mr. Albowski, it's a simple question. If you were called upon in your capacity as a tax accountant to determine the scope of a Peruvian law stability agreement, would you rely on your local PwC team?
In what time frame are you talking about?
In the relevant time frame.
No, I interpreted, my reports are my reports based on my work.
Yeah, but if you were auditing, for example, a Peruvian company during the relevant time frame, would you rely on your local PwC Peruvian qualified colleagues in determining the scope of a Peruvian stability agreement?
An audit would never address whether a stability agreement.
Council, I think it's now 15 minutes past 6. Our proposal would be that you continue your cross-examination tomorrow, and then respondent has the opportunity for redirect, and we may also have questions.
Yeah, I think that makes sense.
I think the attention span is somehow now reached. So we will continue with your testimony tomorrow.
Yes.
We start at 9:30 sharp. And do the parties have any remarks to make today before we close?
No remarks from claimant. Thank you very much.
Thank you very much, respondent.
None from respondent either. Thank you, Madam President.
Then thank you. We'll conclude the day. Have a good evening.
You too. Thank you.